He is no longer with the department, and he has accepted service of our subpoena by email at his request, but then advised us that he is on vacation in Florida and will not be returning to the state until the 25th. We have asked him if he would be agreeable to appear by Zoom for the purposes of this hearing, and he has advised that he would be agreeable to that. But I wanted to ask the court if that was okay with you, and if so, just to figure out how that would be logistically handled.
So the state wasn't going to call until after the 25th as far as in front of the jury?
Your Honor, we were actually not planning on calling Ryan Gabriel. Like the defense said, he is since retired from the sheriff's office. For the motion to suppress, we were waiting upon Lozano, who was the deputy who was right there with Ryan Gabriel.
Is Gabriel the one that went to the garage office and saw the shovel?
He was one of the deputies, yes.
One of the deputies? Okay.
Right, he was a part of that preliminary investigation and search of Solitude Cove prior to the warrant being issued on the 2nd.
That's fine. I'm fine with that. You agree with that statement? No objections to me?
Judge, if we just revisit it after Mr. Lozano testifies to see if it's something that defense needs. I know Mr. Gabriel, I think he got served yesterday, is my understanding. He's in Florida. I'd rather not bother him if Lozano is able to cover what they need. If not, then
yeah, and he's agreeable to it. And just for clarification, yes, he was just served yesterday, but we had applied for his subpoena back in December through BCSO, and that subpoena was not served. So we had to address it this direction. But we've spoken to him. He's agreeable to it. And Mr. Spear is correct. It may end up being after Lozano's testimony that we don't need him. But just out of an abundance of caution, I wanted to let you know that this is...
Okay, let's see where it goes with Lozano. I'm not sure what the last Supreme Court COVID orders were. I know there was no Zoom without both sides agreeing to a jury trial, and I know this is a suppression hearing outside the jury, but then if we do that and it's on the record, all right, let's see what you can go with on first and see.
Okay, thank you, Judge.
Thank you, Judge.
Obviously, I got both consent and it means it. Yes. Your next witness?
State call, Rick Lozano.
Yes. You raise your right hand. You swear to tell the whole truth, nothing but the truth, so you got it?
Yes, I do.
Make sure you speak loud enough into the microphone and address it as you need to state.
Thank you, Judge. Deputy Lozano, can you introduce yourself to the court?
My name is Richard Lozano. I'm a reserve with the Bexar County Sheriff's Office.
And is it Deputy Lozano?
Yes, sir.
How long have you been with the Bexar County Sheriff's Office?
I retired 3 years ago. I was there for 34 years, and I've been a reserve for 2 years.
And during that time on the Bexar County, working for Bexar County, what were the roles you played at that organization?
I spent time in 4 years in the jail. I went out law enforcement. I did 20 years on patrol. I did some time here at court security. I spent some time with narcotics, and I also did community policing. That was my last job.
Deputy Lozano, do you recall being dispatched to an address on? Do you remember being dispatched to an address on Solitude Cove?
Yes, sir.
And what were you being dispatched for?
We were sent to the command center, and one of our deputy chiefs said, hey, you need to go to this address and do a welfare check on a missing person. I was with the SCORE unit at the time, so he sent the SCORE unit out there.
And did you make that address on March 2nd of 2019?
Yes, I did.
And who was with you?
Deputy Ebony Jones, Deputy Ryan Gabriel, and Deputy Ramses Alcala.
And did y'all arrive in separate cars or the same car?
Separate cars.
When y'all arrived at Solitude Cove, what did y'all see upon approaching that residence?
We put up to the house and we noticed that there was damage to the garage door.
Your Honor, may I approach?
Yes.
Deputy Lozano, I'm showing you two photos, marked States Exhibits 20 and 21. You mentioned damage to a garage door. Are those photos of the damage to the garage door we're talking about?
Yes, it is.
And do those fairly and accurately depict the garage door damage that you saw on that day?
Yes.
State would offer States Exhibits 20 and 21 for purposes of this hearing.
Gotcha. Wait a minute.
Deputy Lozano, you pull up to that address and y'all notice damage to the garage door, correct?
Yes, sir.
And you're conducting a welfare check on a missing person.
Yes.
What does the damage to the garage door tell you in your training and experience?
When we got there, we saw the garage door, the damage on it, and that was like a red flag for us. I mean, it was a welfare check, and we said, okay, something happened here that's not normal. If it had been a regular welfare check, we would have gone to the house, there would been no damage to the garage. We would have checked the house, knocked on the door, rang the doorbell, looked through the windows, make sure no one's laying on the floor, and we would have left. But the damage on that garage door raised a flag for us.
You mentioned a red flag. In your training and experience, what were the things that concerned you guys in regards to that
We
garage
thought
door?
maybe someone was hurt in the vehicle. Maybe someone was hurt inside the garage. That's some of the things that ran through my head.
We mentioned that there's a garage door that's broken. Was there a vehicle in the garage?
There was a SUV in the garage, yes.
Based on those concerns you had, based on the broken garage door, what did y'all do next?
We went, Deputy Jones went over to the SUV. He looked inside of it. I went up with him. We just wanted to make sure there was no one hurt in the vehicle. And then Deputy Jones said, hey, there's a shovel in the back seat. And I looked in the window, and there was a shovel there.
What did y'all do next?
After that, we tried the garage door, see if it was unlocked. It was not. We went around to the front door, rang the doorbell, knocked on the door, called out sheriff's office a few times, see if anyone would come to the door, and no one did.
And what was your intent in doing those things?
We just wanted to see if anyone was going to come to the door, and if someone did, then we'd talk to them, hey, what's going on? We're doing a welfare check, what's your name, things like that.
You mentioned y'all go around to the back, correct?
We go around to the back of the house. Myself and Deputy Gabriel go to the back of the house, and the back door was locked. There was no damage to the door. There was no damage to the windows, but there was a window that was ajar. One of the patio windows was ajar. So Deputy Gabriel went into the window. He climbed in through the window. He opened the back door for me. He went over to the front door, opened the door for Deputy Ramses, Deputy Jones, and everyone went into the house.
So as part of this welfare check, coupled with the garage door that you had mentioned, y'all went inside the house?
We went inside the house to see if anyone was in the house. Once we went in to start calling sheriff's office, as loud as we could. No one answered, and we didn't see anything damaged. There was no overturned furniture, nothing broken. Deputy Gabriel started to go up the stairs, and I stopped. I said, you know what, guys? We don't have the warrant to be in here. We need to get out. So everyone got out of the house.
At that point, did you feel like the welfare check and your I guess, search of the house or your check of the house, there was no one in there and y'all needed to get out?
Yes.
How long do you think y'all were inside the home for?
Less than 5 minutes.
I think you mentioned it already, but if the garage door would not have been damaged, what would have been y'all's actions on that day?
Knocked on the door, front door, rang the doorbell, checked, make sure no broken windows. We would have gone to the back of the house, checked the back door, looked through the windows. If we didn't see anything there, then we would have left.
And in your 30 plus years with the Barrett County Sheriff's Office, you've done other welfare checks, correct?
Many, yes, sir.
So based on your training and experience, all the decisions you made that day were based on that training and experience, correct?
Yes, sir.
Can you articulate to Judge any other concerns y'all had putting these things together that y'all saw when y'all made the scene?
I mean, we were just told there was a welfare check on a missing person, and like I said, that garage door was, as soon as we got there, the way it was damaged, it was, we knew we had to, instead of just knocking on the door, we had to go a little further and check the house, and when we saw the window was open, and we said, you know, let's go in here and call it out, see if anyone's home, and that's what we did.
Folks, cell phone can be turned off, please.
Deputy Lozano, you mentioned that y'all checked inside the vehicle because y'all didn't know if someone was injured inside the vehicle, correct?
Yes, sir.
Did y'all have concerns about anyone potentially being injured inside the house?
We didn't know if anyone was going to be hurt inside the house. That's why we looked through the windows. But since that one window was open, we decided to go in and get a good visual of the house, the inside.
So, whenever you mentioned Ebony Jones looked inside the vehicle when y'all were checking the garage to see if anyone was injured or hurt in there, did Ebony Jones communicate that information to you and the other deputies?
He looked into the SUV, and he said, "Hey, there's a shovel in the back seat." That's exactly what there's a shovel in the back seat. So we came up there and we looked, and we saw this brand new shovel there.
When you're saying we, are you talking about all the deputies who were there at the scene?
I'm sorry?
When you say we looked in and saw it also?
I believe it was just me and Deputy Jones went up there and looked. We're the ones that looked into the SUV, if I remember correctly.
Based on the welfare check on a missing person and the damage to the garage door, in your training experience, did y'all have any concern that there was potentially crimes that had either been committed or were being committed at that time?
Yes.
What types of crimes could you potentially see happening with?
Kidnapping, maybe. I mean, you know, that's one of those things that went through my head. Maybe a kidnapping because of the way the garage was damaged. There's like maybe someone rammed the garage trying to get into the house.
Could it potentially have been a burglary?
Could have been a burglary, yes, sir.
Could there have been some type of assault offense?
Yes, sir.
Deputy Lozano, did you make a report on this day on March 2nd?
On that day, no, sir, I did not.
Did you make a report detailing what happened on that day?
On the day when we were there?
Correct.
No, sir.
I'm saying, did you make a report later that
Oh,
detailed
no, I'm
what
sorry,
happened?
yes. Later, yes, I made a report.
Judge, may I approach?
Yes.
I'm handing you State's Exhibit number 23. Is that the report you made detailing the events of March 2nd?
Yes, sir.
Deputy Lozano, when the shovel was seen by Ebony Jones and then you go up to the vehicle and see the shovel, do you communicate with the other deputies that y'all see a shovel in the car?
Yes.
I'll pass the witness, Joe.
You didn't recover, as I understand. You didn't recover anything that's inside. You didn't take photos. You didn't take
No, sir.
clothes out. You didn't take a shovel out of that time.
No.
Go ahead.
We didn't touch anything.
Go ahead.
Thank you, Your Honor. Good morning, Deputy.
Morning.
You said that you were told to go out there by supervisors for a welfare check.
Yes, sir.
Who told you that?
Dale Bennett. He was the I guess, command chief at the time.
You said that was Bennett?
Yes, sir.
B-N-N-E-T-T?
Yes, sir.
Okay. And you understood at that time that the property was searched the night before?
No, sir. We didn't know that.
They didn't tell you about any of the events that transpired on March 1st?
No, sir.
Okay. They just instructed you to go out and do a welfare check?
Yes, sir.
Okay. No other information at all?
No.
Were you aware that there was a missing persons file open on an individual at that
No, sir.
location? That you heard the names Andre or Andreen McDonald?
No, sir.
You didn't know who owned the property?
No.
Okay. All of that flowed through your chief Bennett?
Yes.
Okay. Now, you arrive and you see this garage door?
Yes, sir.
May I approach your honor? Yes. You still have the photograph exhibits?
The judge has them.
Okay, I'm going to call your attention to States 20. Now, looking at that, that fairly accurately depicts what the garage looked like when you all first approached the property, correct?
Yes, sir.
Before you made entry.
Yes, sir.
And we don't see any human beings in that photograph, right?
No, sir.
There are no bodies in that photograph.
No, sir.
You don't see any blood.
No, sir.
There is nothing about the objects that are in that garage that indicates that things have been knocked over, right?
No, sir.
No signs of struggle within,
No.
correct? There's no contraband in plain view, right?
No, sir.
There's nothing about the interior of that garage that's suspicious in any way, right?
No.
It's just the door.
Yes, sir.
That's the question here.
Right.
Okay. So, you talked about the possibilities of burglary, kidnapping, homicide, assault, right? Those are things that are running through your mind.
Yes, sir.
But also, equally running through your mind must be that someone backed into their garage door, right?
Yes, sir. Could be. I mean, yes, it's
That
possible.
happens, right?
Yes, sir.
Okay. Were you aware of the fact that Andre McDonald's commander and people from the Air Force had been out and interacted with Andre that morning and had also seen the door and understood that Andre had backed his car?
No, sir. We didn't know that.
Okay. Were you aware of any connection between the Air Force and that property?
No, sir.
Okay. Also, just to be clear, the car was not running, right?
No, it was not running.
And there's no apparent or obvious damage to that car, right?
Not that we could see, no.
Okay. And even on closer inspection, when you all made entry to the property and looked in the car, there was no damage to the car?
No, sir.
Okay. So, you don't make entry through the garage door, correct?
No, it was locked.
Okay. I mean, and you didn't try to climb over the door, right?
Well, okay, you're talking about the door going into the house?
I'm talking about the garage door is obviously off its hinges pretty significant.
Yes.
You can see the bulk of that
Right.
garage from standing in the driveway, right?
Yes, sir.
But you all didn't climb over the garage.
Yes, we did.
Okay. But first you all tried to make entry through other places in the house?
First place we went was into the garage.
Okay.
You-
You just walked straight into the garage?
We walked into the garage, yes, sir.
Okay. Is it that time that you saw the shovel?
That's when Deputy Jones saw the shovel, yes.
Okay. So you saw the shovel. Now, you don't know why you're there, right?
It was just
told welfare check.
welfare check on a missing person, yes, sir.
Okay. And they didn't tell you who the missing person was?
No, sir.
Okay. So, without any kind of additional information, you see a shovel. Do you see anything else of significance in the garage?
No, sir.
Okay. So then you all proceed to try and gain entry to the rest of the dwelling, right?
Yes, sir.
and you note that the doors are locked, both the front and the back door.
Yes.
And you all, I guess Deputy Gabriel is the one that goes in through a window?
Yes, sir.
And where exactly is that window in relation to the house?
It was on the back patio.
On the back patio?
Yes.
Okay. So when you go through that window into the house, what room do you end up in?
If I remember correctly, I think it went into the living room.
Okay. So you start off in the living room, and you all then walk through the entirety of the house?
No, sir.
What rooms did you go in?
We stayed in the living room.
Did you go into the kitchen?
No, you could see the kitchen from where we were standing.
Okay. Did other deputies that were with you go into the kitchen?
No.
Are you sure about that?
Yes. If I remember correctly, Deputy Jones and Deputy Ramsey came in through the front door, and they came into the living room.
Understood. May I approach again?
Yes.
Can I just see the report that you were to?
Oh, yes.
Okay, thank you. One moment. I'm going to show you what I marked for identification as Defense 37.
Yes, sir.
Do you recognize that?
It's one of our forms, yes, sir.
Okay. And it was authored by you, correct?
Yes, sir.
Okay. And it is descriptive of the events that took place on March 2nd when you all performed this visit at Sawtooth Cove, correct?
Yes, sir.
Okay. I want to call your attention here to this bottom part where you talk about calling out Sheriff's Office. If you can read from there down to the bottom.
Once inside, I called out Sheriff's Office several times so that if anyone was home, they would know that we were there. I looked around the kitchen and living room, but did not see anything in disarray.
Okay, thank you. So you did go into the kitchen, correct?
Well, the kitchen is off to the right. We didn't go into the kitchen and start looking around the kitchen. We stood in the living room and we called out Sheriff's Office.
Okay, but you say in this report that you looked around the kitchen and the living room.
Well, look around this way. I didn't go into the kitchen. I didn't walk into the kitchen. I stayed in the living room.
Okay. But you don't convey that in this report, correct?
No, sir.
I'm going to tender this to opposing counsel and offer Defense 37.
No objection from the state, Your Honor.
So, irrespective of what rooms you did or did not stand in during the course of your time inside the house, you didn't observe anything else suspicious or out of place in the remainder of Mr. McDonald's home?
No, sir.
Okay, so when you are finished with this and you all walk outside the residence, what do you do next?
We went back to our vehicles and waited for someone else to show up. They said CID's on the way out there, and once CID showed up, we left.
Okay, so let's break that down. Did you all radio or enter into your MDT some information about what you all had observed?
Deputy Gabriel we got a key card, an incident number for the welfare check, and I believe Deputy Gabriel is the one that was entering the comments into the computer.
Okay, so Deputy Gabriel generated a report, correct?
Yes, sir.
It wouldn't have just been like a one-liner entry in the MDT, the key card, it would have been an actual report?
It would have been a detailed,
Incident detail?
yes, sir.
Okay. And you didn't offer anything that specific day?
I'm sorry?
You didn't offer any paper that specific
No, sir.
day? Okay. But you also radioed back to dispatch, or?
If I remember correctly, I believe we called the chief and said, hey, look, there's nothing here. We didn't find anything. And they said, okay, just wait for CID to get there. Once they get there, y'all can leave.
The CID was already coming out.
We didn't know that.
But they were telling you when you were finishing up that CID was on its way.
That's what we were told, yes.
Okay. And they wouldn't have, at that point, known anything from what you saw in the garage, right?
No.
Okay. So independent of whatever y'all were doing with that welfare check, CID was coming on out.
Yes.
Okay. Were you aware that there was an order that Andre McDonald be placed under surveillance that day?
No, sir.
Okay. Were you aware of any radio traffic concerning the decision to arrest Andre McDonald that day?
No, sir.
Okay. So fair to say they kept you pretty much in the dark about everything.
Pretty much, yes.
Okay. Did you have any communication that day with Detective Stubbs?
No.
Okay. Have you ever met Detective
Stubbs?
Yes.
Yes, sir. I've met him.
And did you interact with him at all during the course of this case?
No.
Okay. Are you aware that Detective Stubbs made a report, made an application for a search warrant?
No, sir.
Are you aware that he used information based upon your observations and Deputy Gabriel's observations from your welfare check in that application for search
I
warrant?
was not aware of that, no.
Are you aware that he omitted from that search warrant the fact that you all had made entry onto the property?
No, sir. I didn't know that.
Are you aware that he implied that you observed that shovel from where you were standing in the driveway?
No, sir. I didn't know that.
But to be clear, you couldn't have seen the shovel from
No.
standing in the driveway.
No.
You had to actually go up and peer into the car.
Yes.
Right? Okay. You had to actually lay your hands on the car, in fact, right, to actually be able to look into it?
Well, no. You just look in and see it. You don't have to put your hands on the window. If you stand there and look into the SUV, you can see into the vehicle.
Is it tinted?
I don't believe it was tinted. I don't remember if it was or not, but I don't believe it was.
How far away do you think you had to be in order to see it?
I mean, right up to it. You can look in the window.
Okay, but you had to be like standing directly in front of the car.
Yes, on the side of it, looking into the back seat.
Okay. Was it on the seat or was it in the stationary leg?
I believe, if I remember correctly, I believe it was on the floorboard.
On the floorboard?
Yes, sir.
Thank you. That was a better word.
Yeah.
May I approach one more time, Your Honor? Can you show me the report that the state was to you? Okay, I don't know if you have much of a time to review this, but the document I showed you in this report, the text of that report is the same, it just looks different, right?
Okay.
Would you, I mean, do you have any disagreement about that?
No, sir.
Okay. Why would that be? Why do they look different? Do you know? Is this like the raw version and that's like when you put it on the form and make it look all fancy?
I believe so, yes.
Okay, gotcha. I'm just making sure. Pass the witness. Nothing further from the state, Your Honor.
I think you're excused.
Yes, sir.
We ask you be made subject to recall, Your Honor.
Yes. Be subject to recall to make sure you're able to get the issue.
Yes, sir.
Start the state's last witness.
It is, Your Honor.
just have a brief recess to make sure we know which one we're going to call next, who's available. If we maybe can have 10 minutes.
Okay, that'll work.
colleagues are interested and should be here to listen.
And I told him if he is in the tomorrow, it would not be
the purchase of the firearm from Nails. I have here states exhibit number 23. Let me tender it to defense counsel for any objection. For the purpose of the hearing, no objection. For the record, states 23 is a credit card receipt from Nagel's Gun Store from March 2nd, 2019, as well as a handwritten receipt for a firearm to Andre McDonald. And, Your Honor, before we go further, the state has presented its witnesses as far as the motion. I know the defense has a part of their motion, of course, a Frank's hearing, but we'd like to address some of those issues to see if we can get to that level of allow me.
As far as the suppression itself before the Frank's here, do you have any witnesses still on that?
Yes, Your Honor. In fact, several of our witnesses are directly related to the Frank's issue. But I mean, as far as the...
But I'm asking separate from the Frank's issue. Before we get into that, do you have anything on the suppression?
There is, let me see here. As far as actually to go to the question of the material falsehood, the only remaining person would be Ryan Gabriel. There are still, despite Lozano's testimony, a couple of loose ends that I think Gabriel would be able to answer. But apart from that issue, I believe between the exhibits that we've already tendered and the testimony, the false statements at issue.
Okay, then I'll just make the argument from there. So you still want to call Gabriel by Zoom?
We do, yes.
Okay, great. State.
And, Your Honor, I guess for purpose of the record.
I'm not allowed.
We want to object, Judge.
I'm not allowed either way. Okay, let's see. All right. And for the record, I'm doing obviously it's outside the presence of the jury. I know they have some restrictions with COVID about in a jury, but this is outside their presence and only for my consideration on the suppression.
Okay, thank you. So,
See you the next one.
Lugo is going to be our next one. We're letting Gabriel know that we can do this. If the court would like to I told Officer Gabriel that if we could get it set up with you, we call him sometime between 11:30 and 1:30.
Okay, so
And that's what he's expecting. We're notifying him right now that it's been approved, and I can have him log in as quickly as possible, but we have to let him know. But with respect to Lugo, Your Honor, I mean, first of all, there is some testimony about Lugo's involvement in the arrest at Nagels that we want to go into tangential to the fact that he's the affiant on the first search warrant. As far as the Frank's issue goes, misleading information.
Let's do Lugo because that's not on that issue right now, and then we can make arguments and ultimately make on the Franks.
Okay, well, Lugo is
He's part of
the affiant of Warrant 1.
Warrant 1.
And, Your Honor, I guess, and correct me if I'm wrong, Mr. Hunter. I know Mr. Hunter did talk about Lugo's involvement, at least in terms of the detention at Nagels. If he is to call him at this point, I guess it is to be limited to that aspect outside of the Franks. Because you didn't want to inquire outside of the Franks with Lugo, am I correct?
I have a couple of questions for him about the arrest of Mr. McDonald. The principal reason I'm calling him, and the bulk of my examination is going to be about the affidavit and what he knew. And I guess let me get to the real heart of it, Your Honor, explain why we've met the threshold real quick. I mean, this as to Warrant 1.
Yeah, let's go by the warrant. I mean, which one? I got state's exhibit number 1. Is it also Warrant 1 with Christopher Lugo and?
Yes, and it's also defense exhibit number 3.
Is that stage 1? Is that number 1?
It is, Your Honor, yes.
And it should be signed by Judge Roland Ramos, magistrate. March 1st, 2019, Christopher Lugo.
Yes, it was signed by Magistrate Ramos on March 1st at 2 p.m. and it was executed by Investigator Christopher Lugo.
Okay, I'll go ahead and I'll take a look at that and make your argument.
Thank you, Your Honor. We believe that a hearing that goes behind the four corners of the affidavit is essential on warrant 1 for several reasons. First of all, there is a lot of creative drafting in the way that this affidavit reads that pertains simply to the warrantless search issue that we had such discussion about yesterday. The evidence from the hearing and from our exhibits will demonstrate that there was not a sufficient concern or a reasonable enough objective basis for Carol Gambar and Elizabeth Cancel to break into Andre McDonald's home on the morning of March 1st, 2019. Andreen McDonald had been missing for an extremely short period of time. Realistically, you can only say that she was missing for approximately 2 hours. We consider that the primary triggering reason why we think that she's missing is that she didn't appear for work that day. If we expand that to she missed gym, maybe she was missing for 3 hours. The cases that the state has cited for why there would be an emergency doctrine exception to that are simply an opposite. The reality is, in every case in the state of Texas that has gone to the Court of Criminal Appeals on the subject of an emergency doctrine entry to a private premises for the purposes of trying to find a missing person, we are dealing with facts in which the person has been missing for many hours, typically at least 24. We're dealing with situations in which the person was expected to be somewhere or has not reported as normal, but in addition to that, that when people noticed that absence and began to look into it, they began to notice that there was abandoned property from the person. The property of theirs was found in suspicious locations. Scraps of clothing found in a front yard of someone where she doesn't live. Cars abandoned on the side of the road or at residences not associated with the person. Half-eaten plates of food where a person takes their break at lunch. Things that would indicate that someone was not voluntarily absenting themselves from where they would normally be. None of those circumstances are intended to this. And at the core of it, the emergency doctrine expects that the police have an objective and good faith basis to believe, based on the circumstances known to them at the time prior to the entry, that there is a need for them to intervene to prevent someone from being harmed or to render aid. Those things are not objectively manifest from these facts. Carol Gambar's testimony explicitly makes that clear. Her arrival at Solitude Cove showed no problems with the exterior of that residence. There's no sign of a struggle. There's no sign of property being strode out on the front lawn. There's no sign of anything out of the ordinary at that residence. There are no objective indications whatsoever that there might be a problem. With such a short span of time, and with the only evidence that she's even missing being something as trivial as having missed work, and not even a full day's work, that there's just absolutely no way that we could twist those facts up into enough of a bundle to get to the emergency doctrine. The court's been extremely limiting in how that doctrine applies. And in the overwhelming majority of cases that don't deal with missing persons, we're talking about situations where officers are hearing people screaming for help. They see a fight in the kitchen window. There's clear indications of a very recent struggle. And none of that is manifest from these facts. So emergency doctrine is inapplicable. Similarly, there's no real actual license here, despite what Carol Gambar may have implied in the beginning. Carol is a social acquaintance of Andreen McDonald. She barely knows Andre, doesn't even have his cell phone number saved in her phone. Has to contact him through Messenger that day in order to reach out to him. To be frank, I sometimes don't even have Messenger downloaded on my phone. And I frankly ignore 99% of what comes through that app. The reality that someone would be using as a reliable means of communication is just silly. The facts are that Carol and Andreen saw each other socially. Certainly she's been to the house. Certainly when Andreen has invited her, as her testimony indicated, she's come in. She's let herself in when she was invited to do so. To decorate for parties, to attend parties. That's one thing entirely. We all know if you're invited to a party, you can just typically let yourself in. But that wouldn't work.
You argue this suppression theory is whole, or you're talking about the affidavit, why it's
No, Your Honor. I'm explaining these things because these things are set out in the search warrant in a way that is not really consistent with what.
Yeah, but it sounds like you're arguing the whole suppression issue and haven't taken that up yet. I was just taking up the, we're going to have that Frank's hearing or not, the falsehood or not.
Well, let me digress. Let me get to what you're asking specifically. All of that I'm summarizing for you, while it will be argued again in greater force at the conclusion of the hearing, has bearing on the way that Lugo drafted this affidavit. He tries to make this about Maureen Smith's, greeting at the door of Deputy Gonzalez. He later, on page 3, acknowledges that the initial observations of this were the result of Gambar and Cancel's intrusion. But he leads with the Maureen Smith consent issue. And in great effect, I think, waters down the significance of what Cancel and Gambar did. But that's not really all, right? Because we have to assume that the magistrate reading this would have taken into consideration that some of the observations that are in this are the result of a potentially unlawful search. And so the quantum of probable cause, as the state has contended, I think, a little bit inaccurately yesterday, the quantum of probable cause in the affidavit does have bearing on how significant the false statement is. But what I'm trying to arrive at here is, when we read this, the first thing that we know from looking at it is we have warrantless intrusions into this residence. And the way that the order of those warrantless intrusions is described in this affidavit is somewhat misleading. And so I think that those things are significant when we consider that there's not a whole lot left in this affidavit that would be a legitimate vehicle for probable cause. When we get to the material false statement contained within it, which is that they are portraying Andre as having fled the scene when he was confronted by these women in front of his house. And that showed consciousness of guilt, and in light of all the other circumstances, was highly suspicious.
So you're saying that's a falsehood where they said he fled when, I think your brief said that when they knew that he was going to the hospital?
Yes, Your Honor. So Exhibit 1 and Exhibit 2 are Gleason's report and the statement of the gentleman named Brandon Gordon. Brandon Gordon was the clerk at the desk of Baptist Hospital. There is surveillance footage of Andre McDonald entering into that hospital on March 1st, consistent with the observations of the witnesses at the scene, in which he goes to the front desk and he asks if there is anyone by McDonald at the hospital. And he is told, per the statement of Brandon Gordon, that there was someone by that name at the hospital. Now, Andre doesn't follow up further than that. Andre returns back. The testimony, I believe, of Deputy Gonzalez will demonstrate part of the motivation for returning back was to tell these people to quit panicking and to leave his home. He didn't make that explicit, but he was trying to diffuse the situation by noting to them that they've overreacted. The fact that we have Andre leave, but come back in a very short period of time, having actually gone to the hospital as he said he was going to do, having confirmed that there was someone by the name of McDonald at that residence, is in direct contravention of what the affidavit in Warrant 1 maintains as the suspicious behavior of their suspect, and therefore the reason why this is a crime scene. And that drives to the heart of this, because without that, what are we left with? First of all, we're left with a relatively small quantum of evidence, period. We have a small blood stain on the light switch, and a woman's hair in her own bathroom, which isn't much just in the grand scheme. But assuming, for the sake of argument, that that is a significant thing that is worthy of concern, the fact that it's arrived upon only because of an illegal trespass on the property, and that they are trying to, in the affidavit, lay the groundwork for this major misrepresentation about Hyacinth Maureen Smith's overall involvement in whether or not her consent was valid, whether or not her consent was voluntary. That always is really critical when we consider that there's a high probability, any drafter, I mean, just reading from the four corners, any drafter would be thinking to himself, knowing all the facts as the court now knows them, that this is problematic, and that by itself, It would be the kind of thing that a magistrate judge may very well say, come on now, this is ridiculous. You got to bring me something more. Everything that you've all done up to this point is going to get thrown out. So the fact that they lead with that information and then follow it up with a misrepresentation about McDonald's behavior at the premises is crucial to whether or not this warrant survives. So in terms of have we met our threshold, we've detailed and demonstrated that law enforcement knew that McDonald did go to Baptist Hospital, did inquire as to Andreen's whereabouts, and was told that a woman by the name of McDonald was at that hospital. And that he told the deputy that when he returned to the scene. But rather than having that accepted, or rather than trying to develop that further, he's detained in a squad car for hours and hours and hours. I think it's a significant misrepresentation, and one that, in the collective knowledge of all the officers there, is fatal to this search warrant. Now, there are some things that we still need to clear up, and there's some reasons why examination of this witness is important. We've told you throughout the course of yesterday's hearing the reasons why Carol Gambar's initial representation that she and Andreen were such bosom buddies that she was essentially allowed to just come in and roll around all over the house at any time she wanted, whether they're there or not, is inaccurate. We've demonstrated that her ability to gain access to the house was actually pretty limited, and that there would be no reasonable basis for the McDonald's to expect that she could just come in on any given day. And certainly it's not something that society would understand. There's no social expectation that Carol can really lean upon to justify that behavior, especially under the circumstances in such a short period of time. We know those things. We know that Maureen Smith is not there at the time that this occurs. We know that Maureen Smith is elsewhere. We know that Maureen Smith is only brought to the premises after she's been told that blood has been found in her daughter's bathroom. And we know that that was done at the direction of law enforcement. Those things are not thoroughly fleshed out. The search warrant doesn't discuss in detail the advice that Detective Ray provided and why Maureen Smith was at that residence. These are significant issues, and they're glossed over or not mentioned at all in the course of how this search warrant progresses. And because of that, what we're explaining is, if you want to view it through the lens that the state has proffered to you yesterday, that you need to consider this only, and again, I don't agree that that is how Franks works. But I want to lay it out to you that way because they claim that their decision in Harris stands for that proposition. It doesn't. Harris involved a motion to suppress in which the lawyer for the defense had one sentence in a very lengthy motion to suppress that just used the boilerplate phrase. There were misleading statements in the search warrant. And the question then was, okay, how do you make that show? But in the course of the court trying to explain what the holding is actually about, which is you got to say more than just recite some magic words on a piece of paper, the state has taken that to mean that what the court can do once the threshold has been met is limited purely to cutting out the parts of the warrant that don't hold up for truthfulness or that appear misleading and deciding if there's still probable cause. What we contend, what Franks actually contends, with the authority we've cited in our brief, which has not been overruled or distinguished, been cited favorably, maintains, is that once we've demonstrated to you that there's something hinky with this, once we've shown you that law enforcement have made a false statement or a misleading one in this affidavit, and we've satisfied that threshold, then you, de novo, sitting in the shoes of the magistrate, get to ask yourself, on inquiry from all of the witnesses, whether or not, considering factors like credibility and demeanor of the witnesses, considering the totality of all the evidence received and how law enforcement came to know it, whether or not you can believe any representation of fact in this warrant, whether we can demonstrably prove it false or not. And that's the thrust of what Franks is trying to do. We have this general idea for the sake of economy that the four corners of this are sacred and that they shouldn't be looked behind. But that assumes that everyone is doing their job in the upfront and honest way. And we know from the way that this progressed that there were people who were acting in a way inconsistent with law. Law enforcement has inherited those mistakes. And rather than try to own them and conduct a more thorough investigation from other sources, they glossed over them. And then they made up something about Andre McDonald's demeanor on the day in question to bolster their representations of fact and get probable cause from a magistrate. That's why this warrant needs to be attacked from behind its four corners. That's why we should be able to inquire of Detective Lugo what was relayed to him, what information he knew, what did he understand, and what was his decision-making process when he wrote this. That's what Franks allows us to do. And in order for us to have a full and complete motion to suppress that addresses all of Mr. McDonald's Fourth Amendment concerns, that's what must be done. If we can't do that, then we have not had a full and complete hearing, having made an overwhelming showing that there are false statements in this affidavit. That's our position for why we get to cross the.
And that's on the first affidavit?
That's on warrant 1. I can go to warrant 2 as well.
How many do you have?
Well, every warrant the state has tendered to you has problems. And every warrant the state has tendered to you after warrant 2 contains representations about the garage door incident in the shop. And so this is something that has bearing and impact.
How many, I know a lot of them basically include a lot of the same information and some add on. How many falsehoods are there? I know the next one's warrant 2. I'm assuming that the shovel, you saw it or not. Is there additional ones on warrant 3, 4, 5?
On the warrants for the Samsung device that were issued in 2021, there is another area of inquiry that we need to examine, which is a Frank's issue.
Okay, let me let them address the warrant 1 and then we'll go to 2.
Thank you.
Your Honor, our position is defense has failed to show by preponderance of evidence that there are any material misrepresentations, any material omissions, or any falsehoods. First of all, let me first address Elizabeth Cancel and Carol Gambar entering into the house. Defense leaves out several aspects about why these women were concerned and why it was not an illegal entry. And in their brief, they make a conclusory statement that this is an illegal entry. Ultimately, that's for the judge to decide. You heard from Ms. Gambar about the situation, that she was aware that Andre McDonald and Andreen McDonald had a rocky marriage. She was also aware that he had basically attacked her and hurt her in the past. Furthermore, you've heard testimony.
I was going to say that if you just kind of, I was thinking because I see what defense is saying the next day, somebody comes that quick. You'd be surprised if somebody came looking for me that fast, and coming in. But to listening to her testimony, she's got, she knows about them. She's got their background history. I think in the affidavit, in her testimony that he would, if she went missing, he said anytime he would kill her. And they know their relationship. I don't, obviously, like I said, I don't think a friend would come looking for me that fast if I didn't answer the phone or something. But they have that relationship, and she testified, and I found it credible in her testimony. But go ahead.
Okay, and so I'll just briefly lay it out then, Judge. Yeah, of course, this is not a woman who does not show up for work without letting anyone know. This is not a woman who does not answer her phone. We've heard because of her job and because of her position, she's reachable at all hours. Both Judy Lorenzana, her right hand, had not been able to reach her, as well as Carol Gambar and other individuals. It's also the person who doesn't miss her gym workout. And as the court said, even when Carol Gambar had heard on numerous occasions from Andreen, if I ever go missing, I didn't just leave. Andre killed me. Come and find me. All of these things were. In addition to Andreen's medical issues, we know about the severe migraines that she suffers from that essentially cause her to be debilitated. All of these things were within Carol Gambar's head, knowing that this is a situation that needs to be addressed immediately. As the court even pointed out, this is something that's different than from a normal run-of-the-mill scenario between individuals. She knew about the history, she knew about the violence, and that all of these factors that I've laid out are the reason why she went into the house. And defense's conclusory statement that it was an illegal entry, we obviously disagree with, but we believe that the women have reason to go into the house based upon all those foregoing statements. Now, furthermore, the statement in the warrant about the defendant fleeing. You also heard from Carol Gambar as well as from Maureen Smith about when they returned to the house, when all the women were there, that the defendant could not get out of the house fast enough.
Isn't that what they told Lugo? That I know one of them says in one of the defense exhibit or states that that he left, and then the other one was he was in a rush, and it was concerning and just basically fled what he told Lugo, right?
Correct, Your Honor. That he quickly exited the house, and that he even ran to his car and left. So, defense trying to say that this is a misrepresentation. From the women's perspective, from what they're saying, is that he did flee. That he did flee the residence. They did not know at the time if he would return or anything of that sort. He could not leave fast enough and did indeed leave the residence when they tried to question him. Furthermore, Judge, do you want me to continue on in terms of some of the other aspects of the additional warrants, or do you want me to hold it in terms of just warrant number one at this point?
Warrant one, and I'll hear from the defense on the warrant two.
In regards to the defendant going to the hospital, we've also heard testimony from Detective or Officer Gonzalez that he simply asked for a McDonald. He did not ask for Andre McDonald at the hospital. When the deputies followed up on that, there was no Andre McDonald at the hospital because obviously she was not there. The defendant simply stated McDonald, did not go in and actually check to see if his wife was there. It is clear that when the deputies called, they received accurate information. The defendant is trying to mislead the detectives in that regard. Your Honor, in our reading of Frank's, I think that it's fairly clear too. Even if the court were to find that there were some material misrepresentations or omissions or any falsehoods, that none of these things contained within the warrant are actually material. There's still sufficient probable cause in there. And then even if the court were to go a step further and find that there were material misrepresentations, omissions, or falsehoods, and that material and that information was actually material itself, under Franks v. Delaware, the court can simply excise those portions, and there's still sufficient probable cause within the warrant. And I'll even quote directly from Franks, which is 438 U.S. 154. This is page 173 carrying into 171. 171 carrying into 172. And I quote, finally, if these requirements are met, and that's in regards to material misrepresentation, material omissions, and falsehoods, so the court finding that those occurred and that they were material, and if when material that is the subject of the alleged falsity or reckless disregard is set to the side, there remains sufficient content in the warrant affidavit to support a finding of probable cause. No hearing is required. No Franks hearing is required. It's directly from the United States Supreme Court. So again, Your Honor, our belief is there simply are no material misrepresentations, material omissions, or falsehoods. Even if there was a misrepresentation or omission, that they're not material. And even if the court were to find that, you can simply excise those portions within the warrant, and there's still sufficient probable cause. Therefore, we believe no Franks hearing is necessary.
Doesn't the statement have to be, there may be two parts of defense saying about also the omission, but doesn't it have to be a falsehood from the officer himself on his affidavit, not the statement that fled was what he was told by the two women. I mean, so he's putting in there, so it can't be a falsehood if it's being told regarding something else.
Judge, if I recited in an affidavit that you did something really ridiculous on the bench, you were talking to us with a Viking hat on and speaking through a puppet or something, and it was later developed that that observation was completely false. The fact that I heard it from someone, that somebody else said that you did those things, if I have knowledge of its falsity, the fact that somebody else uttered it doesn't cure the issue. The test is it potentially false, or is it a reckless disregard for the truth? And the fact that someone may have said something or described or
They
characterized
didn't
it.
say he walked out of there and he was calmly and got in the vehicle. They said he fled out of there and he was in a hurry.
Well, I understand, Your Honor, but it conveys an incorrect impression. If you were told that your wife is missing and you run out of the house to go look for her, then that could be construed in two ways. You could say that it shows consciousness of guilt because you're the reason she went missing. That's one way to look at it. The other one is that you're frantically trying to find your spouse. And the difference between those two things hinges in large part about what we know in the totality of the circumstances. From Gonzalez's point of view, the non-Afghan, he may well have been of the opinion that it was flight from the scene. But we're not examining this from his point of view, because he's not the affiant in the warrant. We're examining this from the point of view of Lugo, who is in possession of more information, including what we've provided to the court as Exhibit 2, which is the report of Gleason, who went to the hospital and confirmed that Andre went to Baptist Emergency Hospital per the request of Sergeant Beza to see if he'd contacted anyone there at the location. He had contacted Brandon Gordon. Gordon stated that a black male showed up at around 1:32 p.m. inquiring about a female by the name of McDonald. Gordon stated that he asked who he was in relation to McDonald, and he stated he was the husband. Mr. Gordon stated he advised the husband that there was a McDonald and her daughter at room 3. Mr. Gordon stated that the husband turned around, walked out, and left in a silver vehicle. We know, based upon the time and based upon all the facts and evidence, that Andre returned home immediately and advised the Deputy Gonzalez and the women at the house of what he had learned at the hospital. That is just the bedrock objective truth, irrespective of what subjectively was understood by Deputy Gonzalez, because Deputy Gonzalez isn't the touchstone of this. This investigation occurred prior to the execution of the search warrant. This information was being added to the collective knowledge of law enforcement prior to the decision to have the warrant executed. And so that's how we know that it's false. That's how we know that it would be unreasonable, absent a deliberate intention to mislead the magistrate or a reckless disregard for the facts. That's how we know that Lugo's misrepresentation got into this warrant and why it's false, irrespective of what the civilian women at the scene thought, irrespective of what the deputy thought. It's material because this is a closer call than the affiant wanted it to be. It's a closer call because 99% of the information that is used and relied upon in this warrant came from this trespass onto the property prior to a resident of the premises being home and prior to the arrival of law enforcement. And the officers who arrived at the scene, Deputy Gonzalez, just picked up right where the ladies had left off. And this was all something that had to be continued with by Detective Lugo when he wrote his affidavit. And it's material because it's something that is external from what would obviously be, to anyone trained in criminal procedure, a major defect in the warrant.
Any response to vote number 2?
I'm sorry, this is all in warrant 1.
Yes. Any response to that?
Just briefly, Your Honor. Initially, of course, it's in the women's statement as well, but the court also heard from Carol Gambar and Maureen Smith about the haste that the defendant left the house, that he quickly exited, could not get out of there fast enough, and ran to his car. That is not a misrepresentation in any way, shape, or form that was relayed to the officers that the defendant fled the scene. Clearly, from the testimony as well as their statements, that is laid out. In regards to the hospital, defense even read the statement that Brandon Gordon gave. Only a McDonald was asked for at the hospital, not an Andreen McDonald. When the officers checked that, they asked if Andre McDonald was at the hospital, which of course she was not. There is no misrepresentation whatsoever when the officers are saying, we checked and she was not there. The defendant gave incomplete information to Brandon Gordon. The officer's rendition about what happened when we checked is accurate.
But that doesn't, no, it isn't accurate. It isn't accurate. The point of that recitation in this affidavit is to show consciousness of guilt on Andre McDonald's part. And the facts don't bear that out, and it would be objectively obvious to anyone in possession of all of them, as the affiant would be by this time.
Let's move on to number 2, and I am going to, on all these, I'm going to go ahead and consider with all 3 of the things that you hear, not just the deliberate falsehood or reckless. I'm also going to consider the other 2. If I excise, even if I believe that they're falsehoods, if I excise those facts as there's still probable cause or not. So I'm going on that.
Okay, I understand, Your Honor. Again, for that purpose, we would stress that the key to it is, the reason why the test is broken down tripartite that way is because the court needs to determine materiality. And we believe that we have made the threshold showing that it is a material fact within the affidavit in its whole, and that it is false and misleading. Having done that entitles us to have a hearing, so the court can decide to act on it. And that's our position. We disagree with that characterization. Going on to Warrant 2. In Warrant 2, the misrepresentation is that the warrant portrays to law enforcement, or to the magistrate, that there was a shovel observed in the back of that Porsche that was observable from street view or from driveway view when looking at the broken garage door and looking into the garage. That's how the search warrant affidavit portrays the observation, which implies that it's a plain view observation. And that plain view observation...
It doesn't say it was from the street view or driveway. You're saying it...
Well, they neglect to mention that they entered into the premises in the warrant.
I mean, I first read it, I didn't know if it was in the driveway or the garage either, but it doesn't give me the impression that it was in the driveway, but it did.
Well, let me ask you this.
Either way, left it out.
If a magistrate were... I'm sorry, what's that?
It didn't mention it, you're right, it left it out, because I had that question, but it didn't give me the impression it was in the driveway, just said he saw it.
But the test, I guess, in that situation would be, there's only one way to read this warrant in which you don't automatically say that we have a Fourth Amendment violation on its face that would necessitate rejecting the warrant application. And that is if he observed it from a position in which he was lawfully entitled to view. There is no recitation of fact in the affidavit that would support that they had any justification to enter the property. And the court has heard testimony today that clearly demonstrates that they didn't have any kind of justification. The idea of community caretaking as opposed to an acute...
This?
Yes, sir.
They didn't have any... I mean, I honestly, when I first saw the pictures, I don't know where I saw the picture, but I saw it that maybe it's one of these warrants that are attached to the garage with a little crack, and I thought, well, did you try to climb under there or something? And when y'all gave me these pictures, and I saw this is completely off the hinges and stuff. I mean, and obviously the missing person, this is a lot more damage than I thought, and this whole thing is torn down. Go ahead.
Well, there are a couple of things I think we need to keep in mind here, right? Community caretaking is their stated goal, welfare check, right? There's no fact that would justify a conclusion of an ongoing emergency. There's nothing disturbed in that garage. There's no signs of a struggle. There's no blood. There's no body. There's nothing about that garage behind the door that seems out of place or in any way, shape, or form to be disturbed.
It's like the front door was even bigger than the front door, but the front door was kicked in and knocked over. I mean, this looks like pretty bad. But go ahead.
Well, I mean, that being the case, the reality remains that we're talking about a private dwelling, and we're talking about a situation where there is no evidence behind just the injury to the door itself that would demonstrate that there's anyone home. I mean, something else we have to keep into consideration here is we have to judge these things by the collective knowledge of law enforcement. Okay? What we know, what Detective Stubbs knew when he wrote this affidavit, and clearly what the supervisors of Lozano knew when they dispatched these people out there, was that this had already been processed as a missing person case. That a search warrant for this premises had already issued and had been completed, and the scene turned back over hours before, just hours before, less than a full day, less than half a day. In the middle of the night, the scene is turned back over. They know that Andre McDonald has left the home and is not in any danger because they're following him all over town to see if he goes and does something that they can arrest him for. The idea that we can just pretend like, gee whiz, I'm a beat cop and I showed up and there's a door kicked in, I better go and look out. Something might be the matter here. The reason why Lozano's in the dark about these things is not because this is a happenstance event. He's in the dark about these things because the detectives are trying to do something that's a little hinky here. They know good and well that they've searched this property up and down. Andreen McDonald's not there. They know that. They searched this property up and down. They seized cars. They looked in that garage just hours before. They know all of these things. Stubbs knows all of these things. The only reason Lozano doesn't is because they made a deliberate choice not to tell him. But we don't have to play with those blinders. This is an objective test based upon collective knowledge of law enforcement at the time the affiant files the warrant. And so we can say, well, gee whiz, that door looks like it's really off the hinges. But the reality of the situation is far different. You heard some testimony yesterday from Tobelman implying that Air Force OSI was involved in this at a fairly early stage. There's some additional evidence you'll hear in the course of this trial that when McDonald's commanding officer was at McDonald's home that morning, spoke with him, that they called a repairman for him to fix the garage door. On the 2nd, Saturday morning, they went to go check on him because he had a pretty rough night. They told him to take the rest of the week off. He didn't have to report for duty that day. They called to have a garage door repairman come. Chenoweth says that he observed McDonald and that he didn't appear to be in any distress and seemed perfectly normal. We'll present that to you in a moment, Your Honor. That's an exhibit we need to offer. But the collective facts and circumstances leading up to this welfare check, quote unquote, make it abundantly clear that we shouldn't be judging it just from the idea of a beat cop happening upon the scene like that. This is a fishing expedition. It's a fact gathering expedition. It's about the need to get a visual on Andre as quickly as possible while there are surveillance officers locating him out on the street. We know that, by the way, that there was contact between Air Force and BCSO, irrespective of Tobelman's testimony, because we know that Andre was told by his command chain that if he needed internet access that day, there was a library nearby. And that was one of the first places that BCSO conducted surveillance. One of the other things that we would like to get into with Lugo is that, because it pertains to the SHOT team's efforts to apprehend him in Naples.
I'm sorry, Cowboy.
The SHOT team's efforts to apprehend him in Naples. So, understanding all of that, it's abundantly clear that this community caretaking welfare check visit is a ruse. And it being a ruse, we have a warrantless entry into the home without justification. Those things that we have just recited to you militate against the conclusion that a reasonable officer would actually think that someone was hurt or hidden inside. And as you heard yesterday from multiple witnesses, at this point, that house is being treated as a crime scene. It's not a hot crime scene. It's not an ongoing situation. Yes, there's a missing person, but it's been processed. If they wanted it,
obviously something changed. I mean, now the garage door is destroyed, and heard the officer's testimony. You don't know if there's a body in the car. You don't know if she's missing, and so obviously it could be ongoing to that is what he testified to.
well, for all that Lozano knows, it could have been damaged while the police were rifling through his house the day before. The circumstances equally militate towards that conclusion. I mean, we can generalize almost any single thing in the world towards a negative result if we put our imagination to it. We know that that's what they did when they said Andre bought a gun. That he was going to kill himself. There's no evidence of that. Who tries to kill himself and buys 4 boxes of ammunition? But, I mean, those kinds of what-ifs or could-bes aside, the objective circumstances of this don't justify that kind of an intrusion into a home. And the Supreme Court just last year came out with a case. And it's I'll get you the exact citation for it. It's Canigula, I believe, in which they delineate between the community caretaking function as it applies to, for instance, vehicles or people passed out on the street, and the community caretaking function as it applies to a residence. And it's a much higher burden. And it's distinguishable from the ongoing emergency doctrine that's at play in the state's response for the initial private party search. Because at this point, we have even less reason to believe that there's someone there. A complete top-to-bottom sweep of this residence was done. And this is a man who was under surveillance over the course of it. This is a man whose commanding officer checked on him that morning. So, I mean, objectively, from Stubbs' point of view, the affiant's point of view, what Lozano thinks about what that door looks like and what it could be, I mean, that's just taking someone, and I mean, frankly, it's just manipulating Lozano into doing something that they know better. They
Okay,
wouldn't have.
so just narrow it down back to the shovel was seeing the shovel leading out your point of view, the material fact that it was inside there, not in the driveway, was I guess a material falsehood. That's your issue on that.
That's right. If the magistrate should have had an opportunity to decide for himself whether that was an acceptable thing to do or not. That should have been disclosed to the magistrate.
Okay, state.
Yes, Your Honor. First of all, you heard this morning from Deputy Lozano, his reasons for going to the residence at 1042 Saltwood Cove was to conduct a welfare check. When he comes up, and he, as well as the other deputies, observed that the garage door is off its hinges. The state presented a photographic image to the court so they could see the amount of damage. You heard Deputy Lozano state that in a normal circumstance where nothing is amiss, nothing looks different, they might knock on the door, look in some windows, things of that sort. This obviously was very different. Exigent circumstances did exist for them to see because of this extensive damage to the garage door, is somebody inside the garage that's hurt? Is somebody inside the garage or inside the vehicle that is hurt?
There was no time to get another warrant?
I'm sorry, Your Honor?
There was no time to go get another warrant based on what he saw in the garage?
Judge, it's our contention that because of the circumstances the deputies needed, and because of the garage door and the extensive damage, the deputies needed to see if somebody was hurt or needed assistance at that time. So they entered into the garage to see if anybody was inside. The deputies stated to you today that where they observed this shuttle was when they had entered into the garage. They looked inside the vehicle.
Did the other officer, maybe I misunderstood you, did the other officer already see the garage like that earlier? Because he said something about getting it repaired and getting called to get repaired. So did any other officer already know that the...
And Your Honor, I'll lay that out. First of all, when defense talked about Colonel Chatlat and Renzo Hernandez earlier checking on the defendant, when they visited his house, the garage door was not damaged. They spent about maybe 10, 15 minutes speaking to McDonald. They left. After they left, they received a phone call from McDonald asking if he knew a place, a garage door repair place. So he had damaged the garage door.
Phone call?
I'm sorry?
Who got the phone call?
Colonel Chatlat and Renzo Hernandez. From Mr.
command
McDonald.
staff, or he called them and told them, okay. And that's when he also asked him about the internet?
I believe he asked about the internet when he was actually visiting them in the house. After they had departed is when they received the phone call in regards to McDonald damaging the garage door.
So they were the ones that were told, not their county sheriffs or anything like that, that I need to get a garage repaired or something like that?
Correct, Your Honor.
Okay.
And you can see from the second search warrant, one of the individuals that did do some of the surveillance that was referenced by... not a problem. As you heard yesterday from Sergeant Tobelman in regards to the surveillance, the individual, Jay Ward, inside of the warrant is one of the individuals that was doing the surveillance. He observed that the garage door was off its hinges. The score team, which Rick Lozano was part of, along with Deputy Jones, Deputy Ramsey, and Deputy Gabriel into the house. As you heard from Deputy Lozano, they were there simply to do a welfare check. When he sees that the garage door is in that state, that is when he develops exigent circumstances to see if somebody's hurt. As the court heard, they observed a shovel within the back of the Porsche. They did not see an individual hurt. They then tried to make entry into the house and were successful through the back window and called out to see if anybody was hurt. Once those efforts were finished, that's when Deputy Lozano said everybody needs an exit. Then a search warrant was secured. You also heard, and I think the court even asked Deputy Lozano, did you gather anything? Did you search anything? Did you collect anything? Did you take any pictures while inside? And he did not. They were simply there to see if there was an injured person, somebody who needed their help based upon the situation that they saw outside.
Furthermore, and he stopped before they went upstairs, right? And I can see a situation where maybe they did hear somebody upstairs saying, help, or I'm hurting, or moaning, and then going further in. But it seems like he stopped when they called the sheriff, were announced who they were several times throughout the floor, and then stopped it there. Okay.
Exactly, or when that purpose had ceased, that's when Deputy Lozano said everybody needed an exit. Because this is not a search of the residence, this is simply just trying to see if somebody was in need of help at that point. After they exited, or next, defense talks about, the Bear County Sheriff's Office searched this house the day before and were there for several hours. We also heard a testimony that they left shortly after midnight. Nobody had been no sheriff's officers had been at that house the entire morning up until the early afternoon when Rick Lozano approaches and goes up the driveway with the other.
What time was that when they closed?
Your Honor, I believe it was approximately 1 o'clock, or at least after 12 o'clock. I'm not exactly sure on the time, or early afternoon. As the court pointed out, the situation clearly had changed. When they searched the previous day, that garage door was perfectly fine. Now things have changed. In regards, they also point out in their brief and in their motion to suppress, saying that it was a falsehood in regards to the defendant purchasing the firearm. As the state presented to the court today, a receipt of the purchase of the firearm by Mr. McDonald, as well as the credit card, that his credit card was run for the purchase of the firearm. And at least, Your Honor, I believe in regards to the second warrant, of course, that's piggybacking on the first warrant. I believe those were the issues that the defense was addressing. So did you want us to go beyond that, Your Honor, or just hold at the second at this point?
That's fine. We'll stop there.
If I could just briefly respond to that, Your Honor. You'd asked the question, and I want to make sure we're clear. And I call your attention to Exhibit 22, which has been admitted, Defense 22. On page 5, at the very top paragraph, this is a warrant that was later obtained in 2021, in which they're seeking authorization to perform a mirror of a cell phone that was in Mr. McDonald's possession when he was arrested, when the indictment was returned. It says, on March 2nd, 2019, during surveillance at 1042 Solitude Cove, Investigator Jay Board observed the garage door to Andre McDonald's residence torn off the tracks. Andre McDonald departed his residence in a vehicle, and Investigator Board followed Andre McDonald to Abel's gun shop. That is, I think answers it fairly definitively. That this was not something, this, again, it's not just a beat patrolman happens upon this. And remember, no one called this in. No neighbor reported this as a suspicious thing. No one reported that they heard noises in the middle of the night or suspicious activity at the McDonald residence after police departed at midnight from the first search. This was a command-level decision. A command-level decision, which would have had no other information at the time to base it off of. At least certainly nothing's been tendered that would indicate that.
I'm sorry, nothing what?
Nothing's been tendered that would indicate that. The bottom line is they sent those deputies out there on a fishing expedition. And the fact that they relied on this damaged door as a basis to gain entry to his home is a warrantless intrusion without justification. There's no other circumstance, there's no other indication of anything problematic. The garage door being damaged in and of itself is the only piece of information that they have to rely on. And they know that the person who is living there, and as far as they know, the only person confirmed at the house, has left. They saw him leave. They saw him leave in his car. He seemed fine. He didn't appear injured. Didn't appear like there was a problem. They watched him drive away. So I think that any sort of idea that this is a bona fide concern driving the officer's motivation to come in that house is misplaced. What we have here is they warrantlessly entered the home, and then they pretended. I think the best evidence of this is that if it was really so cut and dry, it's now being contended. Why wouldn't you have told them this if they were relying on a community caretaking function at the time that they signed the affidavit? They should have told the magistrate that. They didn't, which tracks up with the fact that it wasn't initiated by any legitimate concern of a citizen. It wasn't stumbled upon by a police officer that just happened to be there. It was a command-down decision in conjunction with a coordinated effort to try and find something on this person because they hadn't found enough evidence to make an arrest based on their search the first day on March 1st. Andre remains a free man. They didn't take him into custody. They're looking for excuses. That's what this whole thing is.
I guess if the Porsche or the vehicle was outside and the garage was knocked down like that is in that picture, you still don't think that that's, let's just say it was outside. You don't still see them, okay, emergency going in to check on the garage door and check if there's a missing person in that garage door. It's damaged that bad. You still think they can go in.
Under all the circumstances that we see, recognizing that this is not an isolated incident where there's not a lot known, right? I mean, which what I guess the court is asking me, and I think it's a fair question, is would this not be something that triggers in the mind the need to want to know more? Sure, I don't dispute that. But the realities of this situation tell us that a lot more was already known, just not by Lozano. That doesn't fix the problem, though, because we are judging these actions on collective knowledge of all law enforcement. And we know that Lozano, no offense, seems like a very candid officer, was being used as a pawn. That the command structure had given him an order to come out there. It was not based on any information he had in his possession at the time that he arrived. That Borg had already surveilled the situation and had observed McDonald leaving the residence, fine, healthy, and ambulatory. That the police had the previous night ransacked his house, looked through everything, found that Andreen was not there. They knew that McDonald's daughter was with his mother. They understood all of these things.
And this search warrant, they're going back and looking for more things. So they're after the fact on this. They're looking for cell phone, electronic communication device.
Well, and yes, that's a separate issue in our issue. This is raised in the initial briefing on the first amended motion to suppress.
I mean, they're looking for more additional things, not regarding the shovel. They're looking for things that maybe can help locate where she's at with this.
Well, the reality of that is that there's just simply no probable cause for that broad of a warrant. The warrant is overly broad, right? They performed a very thorough search, and they collected what they collected. But the idea that in that short span of time there would be any reason to believe that there's anything else of evidentiary value inside the home is based on nothing that's recited in the warrant, except that they found a shovel that they hadn't found before. And the only reason that they found that shovel is because they warrantlessly trespassed on his home. So that's why this is material. But independent of that, I mean, okay, you found a shovel. You didn't find that before. That could have been an oversight. What about finding a shovel in the Porsche leads them to have probable cause to believe that there would be any cell phones, whether there would be any other mere evidence, whether there would be any contraband, whether there would be anything that the warrant seeks authorization for. There's nothing about the warrant or about the facts behind the warrant that would have justified that broad of an authorization based upon what is alleged in the second affidavit. So that's a separate issue. Even if you don't grant us a Frank's hearing, the court should suppress the evidence on that basis. Because if we're talking about a shovel in the Porsche, why are we going through his trash can in the kitchen? Right? I mean, this gets to a certain point where it's just absurd. Why they would think that they have a right to start going through all that additional material based on the representation. There's no probable cause, frankly, for the rest of his house, but the garage, assuming that we find that it's legitimate that they were there to look inside the Porsche. So, I mean, that's just the scope of the warrant issue, irrespective of whether Frank's is granted or not. And again, when we think about how we contend that Frank should be interpreted, it's the sort of thing that you, as the de novo magistrate, get to now critically think about. once you find that they have materially misled the tribunal, when they misled the magistrate. Because you know that they acquired knowledge of the shovel through a means that was without warrant, and then that was undisclosed to the original magistrate. And now, when you look behind the four corners of it, not only can you just say, well, I'm going to pretend that I never saw the thing about the shovel when I'm rereading the second affidavit, but I'm also going to ask myself, why on earth is it that any of the material sought in this affidavit is expected to be found? And is this affiant just full of it? It's a credibility determination you get to make beyond the four corners because we showed you that there was evidence that there's misleading or false information in the document. It's okay.
Yes, Your Honor. The defense talks about the initial search. As the court knows, and as the testimony that you've heard, the situation was not stagnant. It wasn't as if nothing changed at that house during that time period that law enforcement was away. Approximately sometime after midnight, up told them that they come to the house in the early afternoon that day. The clear aspect, of course, is the garage door that is damaged. And of course, we've talked about the exigent circumstances that Deputy Lozano had to enter inside the garage, and also the circumstances of he knew that there was a missing person, highly suspicious circumstances with this garage door being damaged, trying to see if anybody was hurt, if anybody needed assistance as to the entry of the house. The separate issue is the actual warrant itself, the second search warrant from March 2nd of 2019. There's still sufficient probable cause even outside of those issues. We have the garage door that was damaged, that was clearly can be seen from any viewpoint. The fact that the defendant that his wife is missing, the fact that they found blood in the house the previous day, the fact from her friends talking about the conflict in the marriage, that he had hurt her in the past, that she said, please look for me. If I ever go missing, he killed me. And now he's going out to Naples to purchase a firearm. There's still more than enough probable cause within the second search warrant to lay those things out.
Okay. All right. Any other warrants you want to address before I decide on Frank's hearing?
Well,
any other warrants with falsehoods, or they're going to?
We also have some. We also have. I mean, the state has tendered 6 affidavits. Right? Is that?
I think
Total of 8. So we've got warrant 1 March 1st, warrant 2 March 2nd. Then the third solid 2 code warrant on March 7th. Then the geolocation data for Timo. Okay. And then we've got the phones 1 and 2.
Correct.
Which have a total of 4 warrants for those, right? They doubled up the Samsung.
We only put it in the second.
I'm sorry, guys, y'all are talking on the record. I can't hear you.
This is actually,
we're just trying to make it clear.
just trying to make sure I've got my ducks in a row.
Are those going to be the same falsehoods that you're alleging?
Yes,
These
all of
two
these
go
warrants.
and the other ones, that they repeat a lot of stuff and they add other.
All these warrants repeat the same falsehoods throughout,
Okay.
so all are challengeable on that basis.
Okay,
Now, when we get to the Samsung warrants in 2021, there's an additional issue because the first. I'll summarize it for you. We have not yet put on testimony about this, but that's just a timing issue. We have more work to do on this motion. But to summarize it for you, the issue is they get a warrant in 2021 in April for the device that Andre had on his person when he was taken into custody after he was indicted for this offense. Then they apply for a warrant in April for that. And that warrant is as bare bones and conclusory as it comes, right? There's no indication. Understand, by this point, Andre has been in custody. He arrested once and then bonds out. The body is discovered. He's been under indictment for it. A long span of time has passed. And all of it after the operative events of this February 28th early March investigation, because his original phone was seized from him when he was first taken into custody. And so, without any explanation as to why they would believe that that phone contains any evidence related to this case or any other, they basically just say, well, we generally know that, bad guys use cell phones. It's that kind of a warrant. In our memorandum, we sort of explain why that kind of language is insufficient. It appears fairly obvious that was also acknowledged by someone in the investigative or prosecutorial team, because in July of that same year, 2021, a second search warrant is issued. And the second search warrant tries to sort of make it clear why they believe that there's probable cause for that phone. I would submit that on its face it is also deficient. But it appears to me that the more general language of that second warrant about the experience of the officer and the kinds of things that they would expect to find on the phone of someone who's committed a homicide is a lot more specific than it had been in Warrant 1, and oddly almost predictive of the kind of material that ended up being found on that phone. And it seems that based on that, and based upon interviews that were conducted with a witness with whom they believe that Mr. McDonald exchanged text messages in that pertinent time frame after the body was found, there is some indication there to me, based on those interviews, that we have a defiant who has already looked at the phone under a defective search warrant and knows what will be found. And so basically we would not even get to Frank's until Your Honor has first examined the April 2021 warrant and concluded, as we believe you should, that it is insufficient to allege probable cause on its face on the four corners. Now again, I guess there is a Frank's issue about Warrant 1 for the phone, because it contains the same material falsehoods about Andre's flight, about the shuttle, that we're contending with in all the others. But apart from that issue, the additional question under Frank's, are they concealing the fact that they've already examined the phone and know its contents before they apply for the warrant, and they're not telling the magistrate that? I would need more testimony to develop.
What's the last part again?
Well, again, that when they applied for the phone's mirroring in July under the second warrant for that phone, they had already reviewed the contents of the phone based upon the April search warrant. And they didn't tell the magistrate that. They concealed that fact. But it appears that the attendant circumstances of their investigation and the people that they're interviewing make clear that they had already reviewed the contents. And so I'd like to develop that testimony. I need to make my showing by calling the witness and asking about the course of their investigation and what they did.
Yes, Your Honor. You can see, I believe it states 8, if I'm not mistaken. It is the cell phone that we're referring to. And yes, Your Honor. As you can see from the warrant, the information, the probable cause that was developed in order to do a search of that phone was gained, I believe it was March 18th of 2021, if memory serves, when a Sharon Hilton had talked to investigators and expressed the communication that she had with the defendant around the time the discovery of Andre McDonald's body had been done. The search warrant was then gathered in April.
Was that his cousin?
I'm sorry?
You're talking about his cousin, the conversation?
Sharon Hilton is related to Andreen McDonald. They're, I guess, in essence, kind of cousins. She was living.
That's the one she was talking to, or he was talking to, the phones and text messages, and she had two phones and she wanted to turn over one but not the other.
Correct. I believe one was the work phone that she did not want to turn over. She did ultimately turn another one over. She did show the investigators back on March 18th of 2021 some messages between Mr. McDonald and herself. That was part of what was used to develop the probable cause to search Mr. McDonald's phone. In defense's motion, they reference an April 6th, 2021 date. That is when Sharon Hilton allowed investigators to do a download of her phone. That's a different scenario altogether, not Mr. McDonald's phone, Ms. Hilton's phone. Now, the information, of course, used for the probable cause affidavit in April on Mr. McDonald's phone was gathered on March 18th of 2021. Later, as defense reference to July 2021 warrant, our contention is the first warrant is still sufficient, that even if there were issues, additional probable cause was fleshed out in said warrant. However, none of that information was gathered from any search of the phone in April or any subsequent time. All the information was certainly prior to that date. And defense's accusation that we went behind and tried to gather information from this phone, look at that, is inaccurate. And just for purposes, just so the court knows of some of the history, the very limited part that was even looked into that phone in April 2020, or shortly after the warrant was executed in April 2021, there was some communication between the defendant and his attorney. At that point, that any look at the phone was immediately stopped. A tape review was done in conjunction with defense counsel's or the defendant's representation, and that was agreed upon in terms of what actually could be turned over.
A couple of things I'd like to add to that, just for clarification of our position.
We agree.
Yes, the April 6th interview with Hilton that occurred was, of course, after the first warrant issue. And our contention is that material from that dump would have been used in the course of the April 6th interview with Hilton, procuring her phone to be mirrored, and would be indication that it was being used by the investigative team. We were developing that through the testimony of the remainder of the hearing. As far as the issues regarding privilege and a taint team with respect to any attorney-client communication, I just want to make clear my understanding is that what was presented to Mr. Comrie was a list, not exactly to view the items themselves, but an enumeration of files within the phone that the state already believed to be privileged and would not produce, and that was agreed upon and that was entered, and that material was not being used by the prosecution team in any way. We appreciate that has been done. That being said, I don't want that representation to be construed as a waiver of arguments we may make about privilege with respect to things that the state does intend to introduce, because it wasn't as though at the time that privilege discussion was taking place, the defense had the benefit of the full mirror to cross-reference with. Right? This was a sort of a preliminary assurance out the gate. Listen, we know that because this phone was seized after indictment, there are going to be attorney-client communications. We've flagged those. We've walled those people off from the prosecution team. Don't worry about it. And that's great. Fantastic. But we don't want that to be construed as a waiver of privilege arguments that we may make in the trial.
Okay. Here's what I'm going to do as far as the Frank's issue on warrant 1 and 2. As far as fleeing the residence, I don't believe that it's a falsehood, because that's what you want to told Lugo, the detective or officer. Even if the higher court felt different regarding the falsehood, I still feel there's sufficient probable cause to look at this affidavit. If I excise that one issue, which I again don't believe is falsehood, I still feel there's sufficient probable cause. Same thing with warrant 2. I don't feel there's a material falsehood or deliberate disregard for the truth, that he saw it in the driveway or saw it in the garage. It was left off, so again, if the higher court felt different, I still think there's a probable cause sufficient without that in there. Okay, and that'll apply to all the warrants, other warrants. I'll let you take a break and decide, or do you have a witness here ready for anything else?
Well, Your Honor, at some point, in light of the court's ruling, we would like to make a bill as to what we believe we could have adduced from the affiance, irrespective of the court's refusal to consider it and going behind the four corners. We nevertheless would maintain that we have the right to make sure that the appellate court has the full benefit of what evidence we were prevented from producing and applying to the hearing.
I have your witnesses here at 1. I'll go ahead and let them make a bill now in the next 10 minutes or so. 15 minutes, y'all can make it up.
What I'm requesting specifically is, Your Honor, that we make it a formal bill and that we actually take the testimony of the witness. The ruling of the court, notwithstanding the court refuses to consider it, that I appreciate, I respect. But for us to be able to develop our record to its fullest extent and to ensure that the court has the benefit of why we believe the court has ruled in error, we are asking that we be able to call these affiants and put these questions to them so that we can develop what, under what we have presented to you as the Frank standard, what we maintain is the accurate way that Frank's is to be considered, why these affidavits fail.
Okay, state response.
Your Honor, the state would object to any, the court has already made its ruling in regards to Franks v. Delaware, then essentially to allow defendants to bring these people in to develop that on a bill is unnecessary.
Basically, have another Frank's hearing without, let's, I'm going to deny that you can still make your bill if you're the court reporter and say what you, just make your bill that way. Okay.
Thank you. If the court will just note our exception
Yes.
to the court's ruling.
Yes.
We wanted to have a lab testimony.
That's fine. And then at 1 o'clock, I just talk about what witnesses or what you have to bring with any of that. Thank you very much.
And we will want to ask, we have Ryan Gabriel, and we still want to question Ryan Gabriel, and that would not be about going behind the four corners. That would be part of our threshold showing the end of that testimony. We might ask the court to reconsider its ruling.
Yeah, I mean, I'll keep an open mind, look at that, and if something comes up there that I may reconsider on that, I'll do that. But let's have him get on Zoom at 1 o'clock, and then I'll let you make those arguments again if something else comes up that I didn't hear with him. Okay.
Great. Thank you, Your Honor.
So it needs to be muted. Just everybody, I'm on here, not here.
I'm muted. Well, I left the, I guess, now.
No.
I left your audio.
No, I'm not sure. You don't have to say no. You go ahead and go.
May I proceed? Thank you, Ron. Good afternoon, Mr. Gabriel. How are you?
Doing well, thank you.
Can you hear me okay?
Yes.
Okay, great. Looks like you're maybe in a car. Right?
I'm sorry?
You're talking to us today from a car?
Yes, I'm in my vehicle. Yes.
Okay, great. So I wanted to ask you some questions. Do you have a recollection of participating in a search for residents on Solitude Cove on March 2nd of 2019?
Yes, I do have recollection.
And if you could briefly describe what your role on that search was.
I was part of the Sheriff's Community-Oriented Response and Education, also in the SCORE.
I'm sorry, sir. We're having some issues with our
Bobby, can you raise it a little bit more?
On this one? Yeah, absolutely.
We got to raise your volume on our end. It's not your problem.
Oh, not a problem.
Okay, if you could just say something so we can test your volume real quick.
Test.
All right. Court reporter seems to think that we've got good volume now. You were telling us that you were involved in some kind of a community policing initiative with BCSO. What was that called again?
Sheriff's Community-Oriented Response and Education, also known as the SCORE unit. I was part of that unit. We were contacted back in 2019 to go to the listed, it said,
Mr. Gabriel,
Some slow down.
if you can just maybe slow down a little bit. There's a little bit of a lag, it appears, on your end.
Sure. So, on March 2nd, 2019, I, along with Deputy Lozano, Deputy Jones, and Deputy Alcala, were requested by a supervisor to go to this address for a welfare check. When we went there, we conducted a welfare check at that address.
Okay. Now, do you know which supervisor it was that told you to make that welfare check?
I'm assuming at the time it was probably our Sergeant Raza at that time.
I didn't hear the name.
The name again, sir?
I want to say Roger Pedraza. That was our supervisor at that time.
Roger Pedros?
Roger Pedraza.
Pedrosa. Did they give any information about why they wanted a welfare check to you?
I cannot recall at this time why, but we were sent out there.
Okay. Do you recall what time you were sent out?
I want to say it was somewhere between, I would say between 12 and 2, somewhere within that range.
Between 12
and 2.
Between 12 o'clock and 2 o'clock.
Correct.
Okay. Now, were you aware of any circumstances surrounding that residence on Solitude Cove before you arrived?
I want to say we were informed that maybe a disturbance and somebody possibly missing. Again, it's been a while and I really can't remember it fully at this time.
Were you aware that that property had been searched pursuant to a search warrant the night before?
No, I was not.
Okay. Were you aware of the name of the missing person that you were supposedly looking for?
Yes.
Okay. And do you recall that name?
Andre McDonald?
Okay. Andre McDonald was the person you were looking for, or was that the person you suspected?
I'm sorry?
Was that a suspect, or was that the person you were told?
We were looking for Miss McDonald at the time.
Okay. Were you aware that Andre McDonald had been the subject of surveillance at that address prior to your arrival?
No, I was not.
Okay. Were you aware that do you know Deputy Board?
Yes, in passing.
Okay, but you don't have any recollection of interacting with Deputy Board on this day?
No, I do not.
When you arrived at the premises, what was the condition of the garage door?
The garage door was significantly damaged. Almost as if it had been hit by a vehicle.
Okay. Could you see into the garage?
Yes.
Okay. Pretty much the entire garage was visible to you?
For the most part, yes.
Okay. Now, you made entry into the property, correct?
We did go into the garage in which a black SUV was parked in at the time.
Okay. You also went into the main part of the dwelling, correct?
Describe what do you mean by main part of the dwelling, sir?
Well, you went in through a window into the living room. Isn't that accurate?
Well, yes, it is accurate. Through exigent circumstances, yes, we did.
Okay. I mean, I'm not asking you the why. I'm just asking you the where for right now. You went into the living room, correct?
Correct.
And you went into the kitchen?
Yes, correct.
Okay. Any other parts of the house that you went into?
No, I was mostly in the kitchen part.
What did you examine in the kitchen?
I did not see anything unusual that would cause me to say that there was a disturbance in there.
Did you look in the sink?
No, I did not.
Did you look in the trash?
No, I did not.
In the drawers?
No.
Okay. You were just looking around visually in the room?
Correct.
All right. Now, when you went into the garage, you peered into the SUV that you found in the garage?
Yes, for safety reasons, looked into the vehicle, make sure that there was nobody there to pop out on us, and did look into the vehicle with flashlight.
Okay, and to be clear, there wasn't any sign of struggle in that garage, was there?
Any sign of struggle in the garage?
Well, let me put it to you this way. Taking the door aside, just talking about the contents of the garage, you didn't observe anything that was out of the ordinary about the contents of that garage?
No, I did not.
Things were neatly stacked and seemed to be where it would be logical to put them, right?
I guess for the most part, yes.
It wasn't untidy or it didn't look like things had been recently knocked over?
Not to my knowledge.
And there was no damage to the vehicle that you could observe?
Not to my knowledge.
Okay. And that's when you observed the shuttle?
I'm sorry, say that.
When you were looking at the vehicle, that's when you observed the shuttle?
Yes.
And you used a flashlight to assist you with that?
Correct.
And what was the condition of the shuttle when you saw it?
When I saw the shuttle, it was in the rear of the vehicle. It looked like it appeared to look like a fairly just decent shuttle, but it appeared to have some kind of dirt or something on the end of it.
Okay. You didn't see any blood or hair or tissue on it, correct?
No, I did not.
Okay. Now, you wrote an incident detail report about this encounter, is that correct?
That is correct.
And you would have entered the MDT data to reflect time of arrival, you know, how you found the scene, what steps you took, and when you ended the investigation, right?
In the MDT, just very basic arrival, and then I'm just trying to remember this, but very basic in that report page for the most part. We don't put very much on the MDT if not necessary.
Right, so there would be key card entries for you for those time periods.
Oh, yes, there should be, correct.
Okay, so I want to talk a little bit about that. You said that you were basing that off of your memory. You met with the district attorney's office on this case, correct?
Yes, I did.
What was the last time you met with them?
Maybe a few months back.
Like November time frame or like August time frame?
I really can't remember. Again, a few months back, I want to specify a specific month. I don't know.
I understand, but sometime this year. I mean, I'm sorry,
Yes.
sometime in 2022.
Correct.
Not like way back.
Correct.
Okay. And in that meeting, you asked to see your reports, correct?
Yes.
And they were not provided to you, correct?
At the time, they did not have them in possession and were not able to provide them.
To this day, have you seen them since the day that you made them?
I have not seen my report to this day.
Okay. But you are confident that you generated a report and that you would have made key card entry?
I am confident I generated a report.
Okay. And that report would have reflected information including the time that you all were at the scene?
Yes, correct.
Okay. Were you in contact with anyone other than through key card entry or uploading your report after you all had completed your search of the residence?
Was it contact with anybody?
Right. I mean, would you have... You indicated that this was a directive that came to you from someone higher in command, right?
The search or the welfare check?
The welfare check.
Yes, correct.
In other words, you came to that premises because your superiors told you to, not because you happened upon it, right?
Correct.
And did you report back to those superiors when the welfare check was completed?
No, I believe Deputy Lozano was on this spoke with the supervisor at that time.
Okay. Did you have any contact with anyone else involved in the McDonald investigation on that day?
Besides deputies?
Well, including deputies.
There's the deputies that I mentioned from the beginning.
The ones that were with you at the premises?
Correct.
No one outside of that group of people?
Not to my knowledge.
Okay. Were you listening to the radio from any other officers that might have been doing things on the McDonald case that day?
I can't recall this time.
Okay. I want to run something by you, and I want to see if you have any knowledge of this.
Okay.
In a search warrant affidavit that was executed on the 2nd of March, 2019, it was alleged that at approximately 2 p.m. on March 2nd, investigator Jay Borg observed the garage door to the suspect's residence torn off the tracks. He followed the suspect to Nagel's gun shop, where he bought a gun and ammunition. Another deputy, Ryan Gabriel, went to the residence with other deputies and checked to make sure that it was secure. When he approached the residence, he could see inside the Porsche Macan and noticed the shovel that was not present during the previous search of the residence. Deputy Ryan Gabriel backed away from the residence and maintained a watch over it while a warrant was being obtained. Did you hear that correctly? I mean, did that come through?
Yes.
Okay, I want to ask you a couple of questions about that. That paragraph implies that you went to the residence after they had arrested Andre McDonald in Nagel's gun shop. Did you have any knowledge of that?
No, I did not have that arrest me.
I'm sorry, did not.
Can you repeat your answer, sir? The reporter couldn't hear you.
I did not have knowledge of it.
I'm sorry, one last time. I heard the first part, but you cut out.
I did not have knowledge that arrested.
Okay.
I have knowledge that he was arrested.
Did you have knowledge that there was a previous search?
No.
Were you aware that there were objects taken from Andre McDonald's garage by law enforcement at any time prior to your arrival?
No, I did not.
Did you have any reason to find significance in seeing that shovel when you observed it?
I'm sorry, repeat the question, please.
Was there any significance to you about the shovel when you observed it?
No. It was just something I observed, and I reported to Deputy Lozano that I saw as well.
Well, I'm just asking, like, there are lots of things in that house, right? I mean, you observed a pink bicycle over to one corner of the garage. You don't put that in your report, right?
Correct.
You probably saw furniture in the house. You don't identify or describe any of that furniture in your report, correct?
Correct.
But there's a shovel inside of a vehicle and you report that, right?
Yes, sir.
So I'm just asking, what was it that made you think I need to put this shovel in my report? Not, you didn't know anything about Andre. You didn't know anything about what his status was. You didn't know that there was a search there or what they were investigating. Why did that shovel stand out to you at all?
I was aware that there was a disturbance. I was aware that there was a disturbance between Mr. and Mrs. McDonald. That is why we were going to this location for a welfare check. So yes, I was aware of a disturbance, but the specific details, no, I was not.
Okay, so I mean, again, like, you didn't see any blood on that shovel, right?
Right.
And you didn't have anything to compare it to. You didn't know whether that shovel was in there the day before or not, correct?
Correct.
So why note that in your report?
Due to the fact that we were aware that there was a disturbance.
One more time, I'm sorry.
Was a disturbance.
Due to the fact that there was a disturbance. I saw the word correct being mouthed. If I don't hear it, the court reporter can't either.
Yeah, it's not moving.
Was a disturbance. That is why I indicated that in my report.
Okay. But I mean, did you see knives in the kitchen?
I can't recall.
Did you see other blunt objects lying around the house in the garage?
Not to my knowledge.
Did you see anything else that you could have potentially killed or injured someone with in the course of walking around the house?
Not to my knowledge.
Okay. You didn't know any other objects in the house?
Again, not to my knowledge.
Were you aware that officers had found a shopping list on Andre McDonald when they apprehended him?
No.
Was there any talk in your initial dispatch or in any radio traffic or in any discussion at any point while you were at Solitude Cove about a set number of objects, including things like a shovel or a hatchet or an axe or a hammer?
I can't recall.
So it's possible?
Again, I can't recall.
One way or the other, you don't know.
Correct.
I'll pass the witness.
State.
No questions from the state, Your Honor.
Okay, thank you. He's excused.
Your Honor, we actually... He's excused. Thank you so much, Officer Gabriel.
Judge, will we have a second? Can I make a quick housekeeping?
Yes.
I did go over with defense. There was a state's exhibit number 22, which was Richard Lozano's report. It had been marked as state's exhibit 23. I put a sticker that said state's exhibit 22, and we're substituting that in as state's exhibit 22.
Did you get to look at that, defense counsel?
I showed John the substituted 22.
He showed you that.
Okay, that's fine. No worries.
Just for record purposes.
Oh, can I see it real quick? Your Honor, real quick, before we call our next witness, I wanted to apprise the court of a concern that we have. The defense does not have a report from Deputy Gabriel. We don't believe one has been tendered in discovery. Deputy Gabriel has further confirmed this suspicion by the fact that he has never seen a copy of his report, although he is emphatic that he has one. We believe that his report is material, especially when his estimation of the time is between noon and 2 o'clock, because the timing of when exactly they made the scene is a very significant detail. And that's why we wish to take Officer Lugo's testimony, despite the fact that the court has ruled we can't question him about the affidavit. But as to the arrest of Andre McDonald, we believe the timing of this welfare check is significant. So our concern is that this appears to be a very material piece of evidence that we are not in possession of that would be significant. And if the state does have anything to this effect, we'd ask that it be produced now. And of course, we have a greater due process concern about the fact that we don't have it up to this point.
Yes, Your Honor. And in regards to the actual report by Mr. Gabriel, we've asked the Sheriff's Office several times to see if there was any report that was generated. They've actually looked at least on 2 different occasions, if not more. They've done an exhaustive search. We've never found an actual physical report written by Ryan Gabriel. However, the incident detail report that Mr. Gabriel did reference, we do have a copy of that has been tendered to the defense. We're happy to make it part of the record as well. It does show, I guess, their check-ins for when they actually do arrive.
We'll make that part of the record then.
And I have not seen that. As we've discussed before, with 6 terabytes of data, it's possible it was never produced, and it's possible that I just haven't seen it. But I'd like a moment to look at it.
Yes, so we look at it.
And just for purposes of the record, it would be states 24, and I'll tender to the defense so they can observe.
I do want, Your Honor, for the record, for this to be reflected that this report was generated on October 1st, 2021, which I gather means that that's when it was printed out from the system, which would have been the earliest date it could have been produced. The incident date is 3/2, and it notes a time of 13:16 for the incident time, but it appears that this drags on for some time. It looks like it's marked complete at 14:56:50, which would be, I gather, 2 o'clock, 2:46 in the afternoon. But, I mean, those are just things I wanted to note for the record out of that document.
For the record, State's Exhibit 24.
And Your Honor, the October 2021 that I believe the defense reference is just when it was printed out. And then the court can see, I believe it was at 1316 is when the call was generated, or 116 in the afternoon.
March 2nd, 2019, and generated October 1st, 21.
I believe that the October 21st, 2021 was just when it was printed out by us.
Well, and on States 22, the report time, report time 1316, which seems to be consistent with the commencement of the incident detail record that Gabriel entered and that was printed in October of 21. This supplemental report that Lozano authored and that was discussed in his examination appears to have been generated June 8th of 2021. Your Honor, for our next witness, we would call Deputy Patton.
Patton?
Patton.
What's this in relation to?
This is going to go to our motion to suppress for the arrest of Andre McDonald and his unlawful detention and anything that was obtained incident to his arrest or obtained as a result of his arrest and the search of his person.
And Your Honor, just so the court is aware, Deputy Pavlon is one of the deputies that did the mental health evaluation conducted by the Sheriff's Office during an emergency detention at Nagels. I know it's been referenced as an arrest at Nagels, but there was an emergency detention. Deputy Pavlon was one of the deputies that did that evaluation. I'd also like to point out that nothing was obtained from the defendant during that evaluation or even defense's contention that it was an arrest.
So the mental health eval that went to I guess, his command staff in the military? He started with the Bear County Sheriff and then went that way?
Colonel Chatlat had made a decision to command-directed evaluation on Mr. McDonald. When the Sheriff's Office did not feel that Mr. McDonald met the criteria for emergency detention, the Air Force took him because Colonel Chatlat had made that decision for command-directed evaluation. So it's independent of the Sheriff's Office.
And nothing was taken other than, I guess, the hospital with his handwritten.
We dispute that, Your Honor.
That was taken, though, his handwritten shopping list, or say.
It's the state's contention that the shopping list was seized without a warrant at the end of March, pursuant to a deputy going over to SAMC and taking it out of his medical file, and that it had been inventoried when he was taken to SAMC. We are not convinced that that representation is accurate. We believe that going back to how Warrant 2 came into being, that the balance of probability, given how his arrest took place at Nagels and what they did incident to that arrest, is that the police were already in possession of that note at that time, based on their warrantless arrest of Mr. McDonald. And that was a predicate for why this very strange and clearly pretextual community caretaking visitation.
So you think they already had the shopping list?
I think that they already had the shopping list. I think the evidence will bear that out. But
and then how did they go plant it in the hospital records?
They put it back in his pants and then took him to SAMC.
So they had some key evidence and they gave it back to him?
Well, given that they had absolutely no probable cause or suspicion to arrest him at Nagels and they had to let him go 3 hours later because he didn't meet any booking criteria, it was either that or lose it forever. I think that it was a prudent decision from their point of view, albeit an illegal one. But the issue that we have to address is threefold here. First, whether the note is found at Nagels or the note is found at SAMC and how it's acquired, it's warrantless. It's their burden to prove that its acquisition was lawful. They have not put on much testimony at all to that fact. I'm calling these witnesses in part to demonstrate that their proffered theory that they briefed but have not put on much evidence to support, as is their burden, is invalid, but also to ask the court to reconsider the issue of whether or not there are material misrepresentations that would meet our threshold obligation under Franks. And so there are multiple reasons why this witness is being called, and the many other witnesses I have to call after that. I mean, one in particular, Officer Lugo, which I anticipated we would be calling next, apparently has some child care obligation and has been let go for the day. He's under our subpoena, but we need to call him, and I'm hoping we can call him first thing tomorrow morning. He's integral to this issue. But for right now, I believe that the witness we're about to call is significant because this is concrete and actual evidence going directly to the fact that the BCSO takedown of Mr. McDonald outside the Nagels was without justification, in addition to being without warrant. So irrespective of whether the note was found at that time or later through the hospital, it was an unlawful arrest and an unlawful search of this person. But it's a sticky wicket. There's some complications to this, but I'm asserting to the court that our theory at this present time is that the state's representation, which, I mean, I'm not going to accept their proffer. They're going to be put on more evidence if they want to claim that that is their justification for the note. All they have is a nurse who did the intake at SAMC who can't even really attest to what the proper protocol is for a CDE detention. And they haven't met their burden on that. I won't take their proffer. But separate from that, I want to make clear that we are not conceding that what they briefed in their response to us as to how the note came into their physical possession is accurate. So that's the issue.
All right. Just briefly, Your Honor. On March 2nd, 2019, the Sheriff's Office did not collect anything from Mr. McDonald's person. I'm sorry, Judge?
Yes, speak up a little.
Oh, I apologize. On March 2nd, 2019, the Sheriff's Office did not collect anything from Mr. McDonald's person, specifically the note that defense is referencing. As the state did put out with witness Ferguson yesterday to talk about the proper inventory procedure that was done at SAMC when he was admitted, she talked about where the note was found in Mr. McDonald's pants, how the inventory is conducted, how it was stored. She even made a copy of it, which is part of the medical records. But furthermore, the medical records that are in evidence in this case lay out the reason for the command directive evaluation, both approved by, first ordered by Colonel Chatlat, then approved by Major Malik. So that we believe we have established. We are saying that the note itself was collected during a valid inventory at SAMC Hospital.
All that their medical record exhibit shows is that the note was at SAMC. It doesn't mean that that's when it was first obtained. It doesn't mean that there wasn't a search that acquired that information by BCSO officials at a prior time. And the records are contradictory as to whether or not there was any validity to the CDE order. I have more evidence to produce on that as well. I'm getting to that. I have some exhibits I'd like to introduce from the command that I think would indicate that this was not merited or warranted under that, and that this was basically just cooperation. You scratch my back and I'll scratch yours between BCSO and the Air Force to make sure that Andre didn't remain out and at large, despite the fact that it didn't have a good reason to arrest and detain him. I think we can bear that out if you will bear with us and be patient. Your Honor, I intended to offer this exhibit, which is Defense 38, which contains the video of Mr. McDonald's arrest at Nagels. One video in particular, which is the best angle of the actual physical takedown and how the officers process him as they bring him over to the squad car to be transported, as well as still photographs of Mr. McDonald after he was searched and sent to arrest. I think when the court looks at this, there's going to be very little question that unless these officers are just blind, the note would have been found if, as the witness yesterday attested to, the note was found in his pockets, because his pockets are turned out on these photographs. And so I can offer it now. I haven't had a chance to tender it to opposing counsel for review because I was waiting for Lugo to be my sponsor. But if the state might take a look at it real quick, I can tender it to the court now to show why I think this is significant.
Can you give it to me in what exhibit number and the objections?
Let me just, you're saying that this is the video itself?
Should be. It's one of the videos. There are more if you want to offer them for completeness, but I think it's the best angle.
Just one more, Your Honor.
talking about the note that's in the medical records. It states Exhibit 19 with the large gas cans, the attic small, fill the gas tanks, flashlights, large light, that one?
That's
handwritten?
correct, Your Honor.
Okay. And, so your contention, it had already been discovered based on that video over there that prior to the getting in here.
Right. I think either way, whether you accept the state's claim or you don't, it's suppressible under either theory. And I've briefed to you.
Anything else from that you're trying to suppress on that issue right there?
As far,
on this,
that evidence as to how the arrest goes and the timing of when the note is located have bearing on whether or not search warrant number 2 contains false and misleading information and would be an independent ground for the court to consider is to give us a Franks hearing on warrant 2. Because if, as we allege, the note was something that was in collective knowledge of law enforcement prior to the community caretaking visit Lozano and Gabriel testified to, then we would, or if it was part of why the command structure ordered them to do it in the first instance, since both of them have testified that they didn't do it because of anything that they independently knew or thought about from looking at Solitude Cove. They were told to go there by someone who, it differs. We have 2 different names that have been proffered as the possible person who told them to go.
There was no arrest according to the state at that time. They was taken in, I guess, for its mental well-being.
Well, they tackled him to the ground like he was a football player in the NFL without pads. It's pretty violent. It doesn't look to me like it's for his mental health.
And when they search his pockets on that video and whatnot, nobody looks like they have a piece of paper or questions them about any paper or anything like that.
He's whisked off immediately into the squad car. His wallet's placed on the hood of the car. You can see an officer briefly on the video thumbing through the wallet. We then have the still photographs that show that they took his shoes off, that his pockets are turned out. And we know from the testimony of the witness yesterday that this note was found in his pants. So what I'm suggesting is that this is a very poor search, and when you see the photographs, it's clearly not. They did a very thorough search of his pants at Naples. Or they found the note, and recognizing, as they must have based upon the testimony we heard yesterday from the deputy who was the supervisor of this takedown operation, that the reason for the takedown was the arbitrary line of if this American citizen, without a felony conviction, not under indictment for any criminal offense, not under information charge for any act of misdemeanor domestic violence, walks in and exercises his Second Amendment right to purchase a firearm, arrested. That was the testimony the court heard yesterday. So officers at the scene know and understand that there is no articulated purpose to them for why Andre McDonald needs to be taken down and handcuffed and taken over to the sheriff's office. And yet they're ordered to do it. They're following orders. The evidentiary significance of what they would have found would have been critical. And under the circumstances as they found them, they would have no defensible justification for it. And a few hours later, this all manages to come into light because they can't hold him. They have to call the Air Force and see if they can mental health boxer him because he doesn't meet the criteria under state law for an emergency detention.
How did he get into that?
That's what the next witness is.
The witness that I heard already from the medical ward over there with the military saying where I guess you're telling me not to believe where she found it or
No. 100% you believe her because that's where it was. I am not disputing that she found it pursuant to her job at SAMC. What I'm suggesting to the court is,
they looked at it and put it back in.
and then they said go hit the house again because now before hammer, a hatchet, a can of gasoline, those are items in a house, and they're in a house in every house in America practically. There's no evidentiary significance to those things. But if they're all on a shopping list like that, then all of a sudden these things are a big deal, and we didn't get them yesterday. You got to go back and get them. We have to manufacture a second reason to come back into this house, even though we searched it top to bottom yesterday. We have no new PC as to why we need to get in it today. That's why this played out the way it does.
The second time they go back, it's after the the garage.
Well, the time of it is really contingent on what we need to see Gabriel's report. Gabriel estimates the time of this is between 12:30 and 2. The takedown of Andre McDonald is sometime in the 2 o'clock range. There's not that big of a gap between these things to begin with. But the exact time of when this community caretaking event happens is significant. And we don't know it, and that report has never been produced. And I think that this is a problem, given that the officer himself has been requesting his report. The Bexar County District Attorney's Office has been requesting his report. Where the hell is his report? This is a big deal.
And is there any video with him when they transported him from there to Nagels in the cars?
No, Your Honor, there's not a comment video. And Your Honor, just for the record too, I believe it states 24, if I'm not mistaken, the IDR that was entered that showed that Deputy Gabriel, Deputy Lozano, and the others came to the house at 1:16 in the afternoon. The emergency detention takedown that took place at Nagels is at 2:30 in the afternoon on the same day. So there is evidence in terms of what time those things take place.
I can't hear you.
I apologize. The Deputy Gabriel and Lozano come to the house at 1042 Solitude Cove at 1:16 in the afternoon. The takedown at Nagels occurs at 2:30 in the afternoon, according to the video surveillance. So, in terms of when the officer...
After the exhibit 20, after that?
Correct. Yeah, the Nagels happens after the fact. Now, I believe what defense counsel was referencing in terms of the photographs of Mr. McDonald's front pockets being turned out when he is still at Nagels prior to being transported downtown for the emergency detention evaluation. It's showing the front pockets. That's all that it's showing.
You know, this is incident report is 1:16 or 13:16 military.
That's the date of the incident report, yes, Your Honor. But I'll call your attention to the second search warrant issued on March 2nd. I read this passage to Officer Gabriel to see if it jogged his memory at all. But in the March 2nd warrant, or second warrant for Solitude Cove, on page 4 of 7, the affiant, Frank Stubbs, writes, at approximately 2 p.m. on March 2nd, 2019, Investigator Jay Borg observed the garage door to the suspect's residence torn off the tracks. He followed the suspect to Nagels' gun shop, where he bought a gun and ammunition. Another deputy, Ryan Gabriel, went to the residence with other deputies and checked to make sure it was secure. When he approached the residence, he could see the inside of the Porsche Macan and noticed a shutter that was not present during the previous search of the residence. Deputy Ryan Gabriel backed away from the residence and maintained watch over it while a warrant was obtained. If we're to read those words at their face value, the affiant is telling us that the search of this residence transpired after Andre McDonald's arrest, which is a fairly material discrepancy. In a certain sense, it calls into question whether there's a misrepresentation based on the timestamp in the state's own evidence, whether they have made the
They're saying affidavit at the beginning, it says March 1st, 2019 at 1:22 p.m. And then a couple pages later, they're saying approximately at 2 o'clock. He observed it.
Well, this is on March 2nd, not March 1st. On March 2nd at 2 o'clock, this is on page 4 of 7, we've gotten past all of the day one, March 1st events. At 2 p.m., Borg observes the door to the garage damaged, and then he pursues McDonald over to Nagels' gun store. Meanwhile, back at the ranch, Gabriel and the gang show up to begin their community caretaking check. But the way that this affidavit reads, that's the sequence. The sequence is, I see the broken garage door, I take down Andre McDonald, we send people over to Solitude Cove to search it, which matches up perfectly with this issue. And I mean, nothing about the state's evidence from the medical records supports this. All that the state's medical records show is that the note was still in his pants at Sampson, but it says nothing about whether they were observed prior. We know he was searched to arrest at Nagels. And I don't think that these gentlemen, given how intensely they take down Mr. McDonald, with 4 people, 3 with guns drawn, and someone clotheslining him, are going to have skimped on the search incident to arrest bit. That's usually the most fun part. That's where you find the drugs. That's where you find the reasons why they actually get to go to jail for longer, or why you get to add another charge on them. All the things that cops really want to get out of an incident to arrest search. They're not going to pass
I
that
heard their
chance.
testimony, but I would think 9 times out of 10 is the officers are going to say, what is this? You know, they're not going to get way up to the legal arguments you're making, or have the same education as you as a, you know, legal-wise. To not even question Mr. McDonald, to ask him, like, what is this? You know, it's an emergency situation. We're looking for her. What are these notes? There's no questioning of him, or no on video. You'd think that'd be the first thing the officer, not looking forward to 3-4 years down the line, say, well, this attorney may argue this.
Well, if it was a beat cop on the street, I would completely agree with you. But we need to remember this is a case that was going from the top down. Javier Salazar himself is physically present when this warrant is being executed. This is not something where we're just letting an average Joe cop do his thing. Everyone in the BCSO is working to put Andre McDonald in jail. They are working with Air Force OSI to put Andre McDonald in jail. There is a coordinated effort over multiple days to make this happen. The evidence shows that without question. We're using everyone at our disposal.
You're thinking the Air Force is helping them?
Well, I know the Air Force is helping because Commander Chalak is the one that issues the CDE directive, which is what keeps him locked up for an additional 72 hours after BCSO can't hold him because they don't have PC.
And he's still got a job with the Air Force, correct?
I'm not saying that the Air Force is conspiring to ruin his life. I'm saying that at this moment in time, we have a large number of law enforcement resources, very well-educated people, lawyers that consult for the department, people who have 30-plus years of experience, the elected officials themselves, prioritizing this situation. They're all doing something in comparison with it. And so what I'm asking is simply to say, if I'm going to say, well...
I see arguments with the Air Force, any military branch is a different animal completely from, you know, let me work with the Sheriff's Department on this. I mean, generally, rightfully or wrongfully, we like to think they protect, you know, their own, they have their own system. I just don't see them working, let's put this guy away. You know, obviously, statements they've made is they wait until the thing plays out, like it plays out, we're still continuing here, job. I just don't see how...
For what little is working on it.
Okay.
For what...
response?
Your Honor, I mean, it's a fantastic theory that the defense is trying to put forward, but I apologize. It's a fantastic theory that the defense is trying to put forward on this. However, as you can see from the IDR, the officers were there prior to any takedown in Nagels. I mean, we have roughly an hour time period, a little over an hour time period, the difference between the two. We have documented evidence of that. So the defense now trying to say, no, this happened in a reverse order is clearly inaccurate. Furthermore, unless there's something defense can produce kind of showing where this note is actually present at Nagels with the officers, there's zero reports that the officers found any note. There's nothing discovered there. The note was not discovered until he went to Samsey. No search of the defendant was conducted where this note was taken. And trying to suggest that they found this and they decided to just stuff it back into his pocket in a way to try to railroad Mr. McDonald. And it didn't happen.
The burden of proof on this issue is on them. And there's evidence that is not being produced that goes to this issue.
Let me finish. Doesn't sound reasonable or make any sense, but I can see the arguments on it. It just doesn't, okay, not to me at least. Anything else? Next witness?
Yes, I mean, we would ask to call Deputy R. Padley. Can we?
I'm going to look at that exhibit, that video, and maybe it changed my mind. Maybe I
move to admit it. If we could have it admitted.
I'm not going to say that after I say that I changed my mind.
The only thing I would suggest, Your Honor, is it is a lengthy video, so defense can just point you to the time frames that they're, feel is relevant.
Exhibit 38.
It's about an hour and a half long. The takedown is around the 30-minute mark.
30 minutes. Is that, they're telling me about the 30-minute mark?
About the 30-minute mark, I believe, yes. And Mr. Convery makes a very good point that needs to be added. They say, well, you only see the front pockets turned out, then you don't see the back pockets. First of all, it's really hard to get your back pockets turned out on a pair of pants out of the warrant. Secondly, you know that they searched the back pockets because you can see one of the deputies pull his wallet out of his back pocket and put it on the hood of the car. That wallet is on the inventory list as in his pants at Samson. So we know that order of operations doesn't really...
I'll look at it. I mean, obviously we know that inmates get into police cars a lot of times after searches, and you find cocaine in the back seats, and you find methamphetamines, and then you even get into the jail without, after searches. So a piece of paper, I'm not saying it's sloppy police work, but I can see that, but maybe the video is more clear, like you're saying. I'll look at this.
I would encourage the court to take a look. Mr. Brown?
You raise your right hand. Swear to tell the whole truth, nothing but the truth, so you got it?
Yes, sir.
Okay, you go ahead and adjust the microphone if we need to. Your name again for the record?
My name is Deputy Ruben Patlano, badge number 2734.
Madam Proceed, Your Honor. Good afternoon, Deputy. How are you?
How you doing, sir?
Well, I want to ask you about your encounter with Andre McDonald on the 2nd of March, 2019. Do you recall that?
Yes, sir.
How did you have contact with him?
I was on on-call status with the Bexar County Mental Health Unit, and my supervisor called me in and stated I was needed in CID.
Okay. What does it mean to be assigned to the mental health unit in Bexar County?
We basically help out with people with mental illness, so that's what we specialize in, and try to get them where they need to be to kind of get them back in their daily habits,
So you don't have any credentials as a mental health official, but you have training in recognizing symptoms of mental illness?
Yes, sir.
Okay. And you've been trained in terms of Texas law with respect to how to determine whether or not you can seek involuntary detention of someone with an acute mental health crisis?
Yes, sir.
And you know how to evaluate that so that you're not wasting the mental health professional's time when they're making those decisions, right?
To the best of my abilities.
Okay. That's fundamentally what your role is within the mental health unit.
Correct, sir.
Okay. And so you were asked to serve in that capacity and meet with Andre McDonald on the 2nd?
Yes.
And so when you met with him, how long did you speak with him?
Maybe approximately an hour or so.
Okay. So you had a lengthy interview.
Right.
Were you aware at the time of the ongoing investigation with Mr. McDonald concerning the disappearance of his wife, Andreen?
I just knew that he was a person of interest in the missing, his wife was missing. I mean, that's as far as I knew at the time.
Okay. And you know that he had been apprehended outside of a gun store in San Antonio?
Yes.
You were aware that he was full bore taken into custody, he was handcuffed, he was searched, he was placed in the back of a patrol car and taken downtown, right?
I didn't know the specifics of how he got there.
Okay. He had injuries on him when he got there, didn't he?
I don't remember.
Do you recall if he complained about his hand or his thumb?
No, I don't remember.
Okay. You didn't observe any injuries on him?
Not to my recollection, no.
Okay. So, in the course of that, it's a difficult situation because your job is to try and decide whether or not you're going to hold someone against their will for mental health purposes, but you also understand on some level that there are criminal justice implications to holding someone, right? I mean, that this person might be a suspect in a crime. You have to think about both those things.
Right.
So, did you advise him that he had a right to remain silent?
No, I just advised him that I wasn't here to talk about. I was just basically there to talk about his mental health.
Okay. Describe the room that you met with him.
It was in the CID room, an interview room. with a table, 2 or 3 chairs in it.
Closed door.
I don't remember.
What's the size of the room?
The size of the room?
Is it a large room?
No, it was a small room. Small, appeared to be like an interview room. Maybe small. It was small.
Is he handcuffed?
I don't think he was.
You're surprised you learned that he was handcuffed.
Okay.
You don't dispute it.
No, I don't remember if he was or wasn't.
Okay. Did you tell him that he didn't have to talk to you?
I believe so. I just told him that I wasn't here to talk about why he was here.
Okay. Was he free to leave?
As far as I went, no, I don't think he was.
Not free to leave?
Not. I didn't put him there. I just there to have a conversation with him.
You're taught to administer warnings to people if you're arresting someone, right? You've been trained in that.
Right. Correct.
And you know that you're supposed to tell them their Miranda warnings. You have a right to remain silent. Anything you say can be used against you.
Mm-hmm.
You have a right to an attorney. You can terminate this interview at any time, right?
Right.
And you didn't give those warnings.
No, I didn't. No.
Do you know if anybody else did?
No, I don't know.
Now, when you interviewed him, you're interviewing him with those criteria for involuntary detention in mind, right?
Right.
And at the end of that interview, you concluded that he couldn't be involuntarily detained under Texas law, correct?
Correct.
And you recommended that to your higher-ups.
Yes.
How do you report that?
I just recommended. It was in my belief, and through my training and experience, that he didn't meet criteria for emergency detention.
Okay. Was he in his jail clothes, or was he in civilian clothes?
I believe he was in civilian clothes.
Okay. Do you know if there was any property that accompanied him when he was taken?
I don't know.
Okay. Did you speak with anyone after you had your evaluation?
My partner, who's also there with me.
Also in the mental health unit?
Right.
He's the same rank and grade as you?
Yes.
Are? And then did he convey this information to someone else?
I'm not sure.
Okay. You knew at the time that there had been no formal charge filed against Mr. McDonald, correct?
I wasn't sure of that.
Okay. So you weren't sure whether your decision was going to result in him being let go, or if there was some independent reason for him to stay?
Right. I was called to evaluate him mentally.
What's the standard operating procedure for a person's property when they're brought into the jail? Do you know?
When they're brought into the jail,
I'm sorry, is this in the jail or is this in a different building?
it was at 200 North Comal.
Okay.
Yeah.
So that's kind of across the street from the jail?
No, that's the jail address, but at the time, CID was located there.
Okay.
There were offices. It wasn't in the jail setting.
Right, but it's the same building?
Right.
Okay. When someone's taken over there in custody, the property they had on them is taken away from them, right?
Right.
And it's stored somewhere until they're released or transferred, correct?
Correct.
Have you ever dealt with those issues?
In the past, yes.
Okay. What's the general procedure?
How
do those things get checked in?
They're checked in by someone in booking and given a property receipt.
The suspect is given a property receipt?
Right.
Okay. Where did the property go?
In the property room.
In the jail?
In the jail, or depending on what it is.
Okay. Sometimes, like if you found contraband, you would forward that somewhere else.
Right.
You'd alert whatever the arresting agency was, and they'd probably hold it in their evidence, right?
Right.
But assuming it's not evidence, it would just be held in property. Right?
Correct. Yeah.
And by the time you get to interact with someone for a mental health screening, that process has already been done, correct?
It varies. I can't give you a direct answer on that. It varies.
Okay, well, I mean, you are confident walking in there that the person you're interviewing who might be having a mental health crisis doesn't have a weapon on them, right?
It's a pat down. Weapons pat downs usually conducted
By you?
by me or whoever the officer is conducting the interview.
Okay, what I'm asking is, you weren't the arresting officer.
No, sir.
Right?
No.
You weren't at the scene of the arrest.
No.
Right? You were down at CID when Andre was brought there, correct?
I wasn't there when he was brought in. No.
They called you in.
Right. They called me in. Yeah.
Okay. And by the time he got there, though, he had been arrested, and you were counting on the officers to have done their search incident to arrest, right?
I believe so. I'm not sure if he was. But I can't answer that. I don't know what they did before I got there.
I'm not really asking you what they did or didn't do. I'm asking, you have a certain expectation when you go to sit down with someone in custody being evaluated for mental health reasons. I'm asking if that expectation includes an expectation that they don't have weapons on them anymore because they've already been searched and their property taken away.
Through training, yeah, I believe so.
Okay. That would be a reasonable thing for you to assume when you go in, right?
Right.
Okay. After you reported to your partner and this information was passed along, did you have any role in the transfer of Andre McDonald to any other facility?
Yes, after we passed on our findings and our decision to supervisors and CID, I guess a commanding officer showed up from Mr. McDonald's commanding officer, and I'm not sure the specifics of what was talked about, but we were asked if we could help give a courtesy ride to SAMC.
Okay.
Or BAMC, excuse me.
So the commanding officer came down to CID.
Right.
And you saw him?
I believe so, yes.
And at that time, you were asked to help transport him to SAMC, right?
Right.
Okay. How does that go down? What's the process for transporting someone to a military facility for mental health watch?
It was more of a courtesy ride. We let Mr. McDonald know that's what it was, and we went down there and walked him into the front door. That's how it went.
Okay. No independent search of property or pat down or anything else on your end?
A pat down was conducted.
By you?
By me or my partner.
Okay. Prior to getting on the bus or after?
In our Tahoe, our unit.
Gotcha.
Yeah.
Prior to getting in the unit.
Right.
Is it an above closed pat down or in the pockets pat down?
No, above closed.
Okay.
Yeah.
Do you have a point of contact over there at SAMC? Would you have known your counterpart who would be receiving Mr. McDonald upon arrival?
No, I don't, only because it was a courtesy ride basis.
So you just call the front desk and say, we're bringing this guy in, he needs to be processed?
The commanding officer met us there.
I see.
Yeah. Yes, sir.
In your pat down of Mr. McDonald, did you find a wallet?
I don't remember.
Did you find keys?
I believe he had keys.
So there were objects in his pants when you were interacting?
Keys do sound, I think, yeah, I think he had keys.
Okay. Did you have eyes on him the entire time from the time that you began the mental health evaluation to the time that the commander arrived to the time that you put him in the back of your tie? Or was there a period of time where someone else was dealing with it?
No, once I stepped out of the room to pass on the information to the CID supervisors, I wasn't in the room with him.
Okay. Other people were taking care of him around
Right.
once the commander came and said, I want this to be referred to our hospital, right?
Yes.
Okay. So you don't know whether he had items like keys on him while you were interviewing him, whether those were returned to his pants after your interview. You wouldn't know that.
No.
But suffice it to say, the pat down you gave him before he got in the Tahoe, he did seem to have items in his
Yeah, he had items, but I don't remember what they were. They weren't anything that posed a threat or danger to me or my partner.
Is that unusual?
No.
People get their belongings back when they're done. I mean, like, that would be the common way that something like this would be done.
Every situation is different. I mean, I didn't. Again, I was just there for his mental health evaluation and giving him a ride as a courtesy, and I explained that to him.
You said you had done some work in the property room before, right?
No, I didn't say that. No, I've never worked in the property room.
Gotcha. But you just weren't looking at anything.
I mean, I've made arrests before, and that's usually the process.
I see. I'll pass the list.
We don't have any questions for this witness, Your Honor. May he be excused?
Thank you, excuse me.
Thanks, sir.
Yes, sir. Subject to recall. Your Honor, our next witness is hopefully going to be Ruby Garcia, but I need a moment to make sure that she's still here. If I can step out to the hall.
How many more witnesses, Congress, do you anticipate? How many more do you anticipate, or check with?
That's what we're trying to do.
Counsel.
It's getting to know.
Okay. All right, let's take a 5-10 minute break, and we'll come back see when he gets to the witness.
Thank you.
concern is based on the defendant's defense counsel's memorandum in their motion to suppress is calling Detective Garcia for a Frank's issue. That's the second problem. The court's already litigated this issue. So if defense wants to proffer what the reason of calling Detective Garcia, if it's something outside of Frank's, perhaps it can be addressed. Otherwise, the court's already made a rule.
I think we agree these are two generic labels here. We are raising a Frank's issue, and we have a right to try and make a preliminary threshold showing to entitle us to go behind. Oh, sorry, 1 second. There's an objection request.
Okay.
We have a right.
Which one was she applying to? The cell phone?
She's with regard to the cell phone that was seized after Andre was indicted.
Which date is that affidavit dated?
These are the April of 2021 and July of 2021 search warrants.
The July 19, 2021, Exhibit 22, and
These would be defense exhibits.
21.
Defense exhibits 21 and 22, Your Honor.
And it's State's Exhibit 8 is the July 19th, 2021 warrant.
The issue is this. The court has ruled, as far as the material false statements that we've discussed relating to the investigation in March of 2019, that it does not believe we have the right to go behind the four corners. And we've asked to proffer our testimony on that. That was denied. We intend to make a bill. With respect to the defense exhibits 22 and 23, these 2021 search warrants, obviously all of the same issues do apply, and we think there's a Frank's issue still in play for those things. But there's another issue, which is that we contend that in defense exhibit 22, defense exhibit 21, the April 1st, 2021 warrant, we would contend that on its face, irrespective of the Frank's issues we believe that it contains, that on its face that warrant lacks probable cause and that it should be denied. It is the most bare bones affidavit conceivable for a cell phone. And the case law in this state is very much against that kind of a boilerplate document being sufficient.
Let me see if I got it right. Out of that one and the other two, I mean, it seems the weaker of the three, but looking at that affidavit too, the facts still support probable cause. There's same facts relating to previous warrants, including information that I guess they got after the second search warrant was executed.
Well, here's the problem.
When they found, I guess, where it was found that the defendant purchased a shovel, I guess the axe, hatchet, bags, gallons, and it lists the other items that were found. Also, the hammer blood evidence with victim's blood on it. And then July 2019, the skeletal remains were discovered. The cause of death was a blunt force trauma. I guess the phone had been kept in a secure property evidence room at that time.
Yes, Your Honor.
And I guess you're saying that it may contain evidence that the murder was committed by the suspect.
And Your Honor, the probable cause for that was developed March 18th of 2021, as stated in the warrant, when a Sharon Hilton had communicated with investigators about communications that she had with Andre McDonald in regards to the discovery of Andreen McDonald's body. Those messages were shown to investigators, and as part of that communication between the two is then added on to the previous probable cause developed to the search warrant for Mr. McDonald. So
I understand that boilerplate language, the courts don't like it, and they don't want mere, I guess, speculation. And you were arguing earlier, but on this one, even though out of the three, that the April 1st might be the weakest, it's still sufficient facts. I mean, some of the cases that I looked at, I guess the Court of Criminal Appeals in Baldwin, I mean, they didn't go further. It was just a boilerplate language. But here we have not just a boilerplate language, but sufficient language that supports probable cause and linking the defendant to the facts committed in this offense.
Nothing after this is not for the phone that was on Andre's person when he was arrested in 2019. That phone has been in evidence for a long time, and we would maintain that The warrants for that phone are deficient for the reasons that we've been litigating up to this point. That's a separate issue. But as to the phone at issue now, this phone was obtained after Andre McDonald gets out of jail.
Yeah.
And after all the facts pertinent to the investigation and all of the conduct that's alleged that Andre McDonald
And after the
engaged
body
in.
was already found, right?
Well, the phone was obtained at a time and place when Andre is no longer in jail on his tampering charge. The investigation has not developed any new leads pertinent to Andre. It doesn't recite any investigative work done after those events in March of 2019. There's no new information. There's nothing that indicates in the affidavit even when Andre purchased the phone. On its face, the affidavit does not give the court anything to particularize suspicion or cause to that new phone. It's purely just...
Whose phone is that on the I know it's a Samsung mobile phone and has a serial number, but whose phone is that?
It's Andre's phone.
It's Andre's
that
phone.
he purchased after he was done on his custody for the tampering charge, after March of 2019.
And who's the phone that they're trying to get on July 19, 2021, Exhibit 22?
Same phone. They're trying to fix. They obviously see
Well,
the
that one's a lot better. It's thorough and it's the same evidence recovered from.
It's the same phone. Same. They're trying to dump it twice because the first warrant has no facts that reveal any investigation after Andre is taken into custody of the tampering charge.
But it's the same evidence. Like the search warrant in July. It's not new stuff that came out of that phone or.
That phone, when the phone is in their possession in 2019 when he's indicted for murder and Andreen's body is found, and it just sits there and they don't do anything. Then we can go all the way to 2021. Stages have progressed. Andre's case is progressing. The state wants to get in that phone. Now, they can advise you, but they're going behind the four corners. If we're thinking about just warrant 1 on phone 2, whatever their reasons, they're not articulated in that document. That document basically is the problem that Baldwin identifies. It's just someone saying, well, this person we think committed a crime, and criminals use phones, and the phone probably has some evidence on it because everybody's phone's got their personal life on it. We want to look into it. It's essentially just a general warrant without any particularized probable cause. That warrant issues on April 1st of 2021. The fact that a second warrant for the exact same piece of evidence that has been in the property room the whole time and has never been accessed.
It includes all that evidence, so right, as far as the bags and the blood evidence, everything that the original warrants found, all these other things, and now her body, right?
And now we're what?
And now her body. Like on top of all the other things, the plastic bags, the gloves, the gallon, it includes July 2019 because they're coming later to 2021. Her skeletal remains were discovered, so and the cause of death. I mean,
the body was found in the interview.
I'm sorry, we're going to try to...
More than the Baldwin case listed. Okay, I see.
Well, but can I just explain why we think that this is important?
Okay, I'm going to deny it. And I'll deny it, and then some of you have any other witnesses. I looked at Exhibit 38. I guess there are any more arguments on that too, but I can see where looking at this, I'm not saying that I believe your theory that they found at all, not even close, but they found the receipt or the note and put it back in there, but your arguments about illegal arrest, I'm looking at going into the store, going to buy a gun. There's been no body yet. He hasn't been charged with that. I'm listening to those arguments that they do tackle him pretty hard. They slam him to the ground, and that's a mental check. I know they had to make sure that he wasn't coming out with a gun. And I mean, more likely to be in a box, and I'm sure they had other officers in there already watching him. That's the other testimony. So it's not like he was coming out with a loaded gun and slamming pretty hard at the pole, and then they said, well, now we're taking him over here to get checked for mental health. I mean, he wasn't even charged with tampering at that time yet, right?
He was not, no. He did not, the arrest warrant for the tampering did not come out until March 3rd.
And then that would, if I do go that way, I'll listen to those arguments again, but if, that would take out or say have response, take out the handwritten note with the items, not the items themselves. I don't know how they came through, which warrant later, but that would take out the items, the list.
Well, and you know, it's important to said, he was, after he was detained, there was an emergency detention. I agree, he was in custody, like he was clearly not free to go. However, a search of him was not conducted. An inventory search at SAMC is where the note was discovered. It was not discovered by law enforcement. The reason he was at SAMC was an independent reason. The command directed evaluation ordered by Colonel Chetlat and approved by then Captain Molly at SAMC. That is how the note comes into play. So we would argue that it's a separate issue. There was no search conducted of McDonald on March 2nd by the Perry County Sheriff's Office. That
Well, he's got his pockets out, and he's got, you know, the pictures and stuff. So they put the wallet there on top of the car. Obviously, they're taking photos of his car, opening his car, taking pictures of the Jaguar. I guess you're going to say that that isn't sufficient attenuation, that now that he's in the hospital mental, that was the reason for the arrest when they get over there.
Right. I mean, it's clear that this wasn't actually set out to be a mental health screen, but that ends up being the only thing left that can be relied upon. We end up there, but we can't even satisfy state law for the emergency 72-hour hold, so we have to enlist Air Force procedure, which is a little bit more wiggle room to make that happen. And I think we can demonstrate, Your Honor, that there really wasn't a good reason for a boxer to be placed on it. And I have some more evidence to produce on that. But the issue is this. Whether the note was found on his person at Nagel's, whether the note was obtained at the end of March when the police came and took it from his medical file, we would contend that the note was unlawfully taken, either direction. There's also a Rodriguez argument we submitted in our brief, which is if we really kind of break this down and think about it, this entire process is an unlawful prolongation of his detention, which was never justified from the beginning. And so at any point along that road, we have a situation where he should not have been held, and his belongings that were on his person at that time should not have been seized. But we're also maintaining that it seems that it's really unlikely, based upon what Your Honor has seen in the video and those photographs, that something that significant would have gone unnoticed. That almost assuredly hands of BCSO officials touched that note when he was being searched at Nagel's. We know he was searched. I think that issue is critical because we know that is not a lawful arrest. And it puts into issue a question, because we have a discrepancy in time about when exactly this caretaking search on March 2nd, it's the issue of Warrant 2, took place. And that is a significant question that needs to be resolved. Gabriel's report doesn't exist. He knows he wrote one. He knows he submitted one. The Bexar County DA's office has asked for it and can't get it. Gabriel has asked for it and can't get it. He knows he submitted it. Where is that report? That report is something that is really critical for us to have.
Gabriel, the garage is destroyed, right?
The garage is destroyed issue. And Your Honor, we're not. There's more evidence I want the court to consider about that. And there's some timing issues there that I may have to call this witness in the morning. I know that we have tried the court's patience. I'm sympathetic to that. We don't have many people left, Your Honor, but I think that what we have left will help to show more about why this is a bigger question mark and a bigger uncertainty than it might otherwise appear right now.
Yeah, I mean, I see on the pictures he still has pockets up here that aren't open and buttons right here. He has his back pockets that aren't searched. It's a piece of paper. And you want me to say that they knew it was there and they didn't, one, question him about it on the scene. Two, tell him, hey, we're going to, try to make an arrest on this. Or, they just put it back in there. That doesn't make any sense. And I know you're saying, well, Saul's Army Command was there for the top, but not the guys that were tackling him.
But how does the wallet get back in the pants? We know that his wallet gets back in the pants. You saw it on the hood of the car during the takedown. And by the time he's being taken over to SAMC, he has belongings in his pants again. How does that happen
And
in a situation
the
like this?
time lines up more with what the prosecutor is saying. That's the other thing, is it just, you said it was about an hour later that the officers that are at the scene of the garage, it's about an hour before he's arrested at Nagels.
Yes, Your Honor. The video, I believe, was defense 30A.
38.
And I understand defense is the purpose of it to kind of show the takedown. However, the grander video actually shows the time that it took place. It was at 2:30 in the afternoon. So, as you saw from the IDR, where Ryan Gabriel, Rick Lozano, and the other deputies were there, it was at 1:16. And so approximately an hour and 15 minutes, roughly, in between. So, what happened at Solitude Cove happened prior to the takedown in Nagels.
And that it makes a lot more sense that way. Just for this, hold on. With the time stamps and all this, it makes more sense. And then looking at Orville's, or who's the detective, or who's with the V?
Lugo is the first detective on the search warrant. However, the subsequent search warrants.
No. Who was the officer with the V initial that started off? Went and saw the garage like that. And
Okay, that's Jacob Warren.
Warrant.
B-O-R-G. Yes, he's the one that's referencing Warren.
It seems like he's there from all these timestamps that are matching up. He follows McDonald and he makes a call to somebody to go make, or somebody makes it, go make a check at the house, which coincides with the timeline. I mean, you're looking at Nagels, it's closer to North Star Mall. Where he lives is way up 281 Wilderness Notes. That's a good 30 minutes, give or take, even with traffic, without traffic. Then on this video, he's inside the store for 30 minutes before they make the arrest. And then they make the arrest. So it's about an hour and 15 or so difference when they said they were there at 1:16. And an hour and a half, hour and 15, 20 minutes later, they're making the arrest. It flies just with the time that he drives down there. I mean, it makes more sense. I'm obviously not in the car, but I know the area and I know both areas. And with these documents showing the time, it just now makes sense what they're doing. They're following these other witnesses that I heard say they didn't know an arrest was being made or nothing had been made because the arrest was after the fact. Based on the travel distance, based on the videos at the Nagel store, based on these supplemental reports.
But Judge, there's one key thing I want to make sure we're not overlooking. That the only concrete sworn report about the chronology of these events, right? Remember, we have the report that's entered in after the fact. That report that says it's at 1:16 that you referenced, that matches up with arrival time for the caretaking team from what Gabriel's testified to. It was a report authored days later. All that stuff unsworn to. But the sworn affidavit of Frank Stubbs, which is the basis for the issuance of the second search warrant on March 2nd, says that at 2 o'clock p.m., Investigator Borg observed the garage door to the suspect's residence torn off the tracks. He followed the suspect to Nagel's gun shop, where he bought the gun and ammunition. Another deputy, Ryan Gabriel.
And I see it, and it says approximately 2. 1:16, 2. This is an officer that's following Mr. McDonald to the Nagel store. He's sitting out there, they're watching him. He may not even realize the time period that McDonald's in that store longer, 30 minutes longer than he knows, because they're taking pictures around the car, they're looking. So,
but if you're not going to go behind the four corners, why can't we? The issue is that we were assuming.
Hold on, talking. He says it's approximately 2, so I've already made a decision on everything. All right?
I just want to make it clear, because I can't go behind the four corners, the court is giving deference to things that are not sworn to, and assuming that those things were either mistakes or that they're, this or that or the other, or taking judicial notice. The court is considering things behind the four corners. But I can't, even though we have a discrepancy here within the sworn statement.
Yeah, that's not true. I made my decision. She's not going to testify. Okay.
So, Your Honor, just to make sure the record on that is complete, because we went down a rabbit trail. The reason why we need to call Ruby Garcia is
trying to follow you and whatever trail you're doing.
I understand. I just want to make sure that this is clear. The reason that we're calling Ruby Garcia is not about these issues, even though some of these issues would also affect that affidavit. The reason we want to call Ruby Garcia is because we contend that the first warrant in April of 2021 for that phone violates the concept that you can't use a bare bones recitation about how criminals generally use cell phones to get into somebody's phone. And that there are no new facts to the investigation except the discovery of Andreen's body, which is skeletonized, which is consistent with the fact
And I
that
already
she
told you several
died.
times that I find there's sufficient probable cause in that April 1st, 2021.
I just want to complete my record. Assuming that argument is correct, assuming the Court of Appeals disagrees with you and finds that this warrant is insufficient, then the second warrant that issued would be the only thing left to defend the mirror of Andre's Samsung device that he obtained after he was arrested. And that warrant, we maintain, was based upon, although it's not disclosed in the text of the warrant, that warrant was obtained because Ruby Garcia was able to look at the dump. And if the first warrant is invalid, as we maintain, that observation of the phone was an unlawful search of his phone.
What's your response on the second warrant? Because that's even stronger.
Your Honor, first of all, the second warrant contains even further probable cause to justify going to the phone. Furthermore, as the court can see, as the chronology of the information is laid out by Detective Garcia, all of the information, the probable cause was developed prior to April 1st, 2021. That is within that warrant on July.
And that's been done before, though. I mean, they go back and get another warrant. Of course. We've had cases ourselves that have been upheld, so.
Absolutely.
What I'm saying is,
I apologize. The only amendment that I would ask is it does also talk about historically the information that Sharon Hilton shared with the investigator showing him the messages between her and Mr. McDonald on April the 18th. Later, the state even confirmed that once they got a consent from Ms. Hilton to actually show the download of her phone match the same messages that she showed. That's the only exception. Other than that, no information within that probable cause affidavit from July of 2021. None of that information was gained after April 1st of 2021.
But Your Honor, I would just submit, when you read the text of the warrant, the reason why it is more detailed, and the only ways in which it are more detailed, are the sorts of things that if I would have a really tough time saying confidently, unless they had already seen the phone. And I believe that we are entitled to question this witness about the investigative steps that were undertaken between April 1st and July of 2021.
Let me talk to the other witnesses.
Your Honor, that's the last witness we have available today. Officer Lugo, we wanted to question about the Nagels component, even though we're not going to be allowed to question him about Frank's. And apparently there's a child care issue.
Lugo, you wanted to question about what?
About the Nagels, the arrest of Andre McDonald, and how that relates to what was going on with the caretaking team at Sawtooth Code. We anticipate that evidence is our last opportunity to make our showing to convince you that we are entitled to have a Frank's hearing on Warrant 2. It's essential to our case, and I don't think it would take very long. We have two witnesses tomorrow, Your Honor.
Lugo and who?
Lugo, and then the other one is the name that's pronounced that you find the list.
So Lugo's more back to the false statements or omissions. I'm already listening and kind of...
Lugo's not about the false statements. Lugo is about how the takedown occurred. The testimony we received yesterday about the takedown was more from the eagle's eye view of I'm coordinating this and I watched it happen. Lugo actually made
You're just trying to strengthen your argument about suppressing the written document, receipt, or note, or...
Well, it would strengthen the argument to suppress the note. It would also be important, I believe, to have questions about Lugo to complete our offer of proof as to why we're entitled to a Frank's hearing, so that your denial can consider all of the evidence that we think would be significant.
Okay, your response on that?
Just briefly, Your Honor. First of all, the defense exhibit showcasing the takedown at Nagels is already available to the court's view. That's already admitted into evidence in terms of having to ask Officer Lugo about it. You have it on video. You're able to see it right there. And then the other aspect is you've already written on Frank's. Nothing further needs to be developed.
Okay, I'm going to deny that. Any more argument is this is like denying that you read the other witnesses?
Yes, we also want to call Renzo Hernandez, who's an Air Force officer that would have matters to attest both to the boxer issue and mental health of Mr. McDonald at the time, and also he was a first-hand eyewitness of the condition of the door on March 2nd, and we can dispute that the condition of the door, as the court has observed in that photograph, yes, Your Honor, is the condition in which it was originally found, which I think is a critical component to this. It's also why Lugo's testimony is going to be.
So you're saying the door wasn't like this?
The door wasn't like that. That's our contention.
Before they, okay. And, yeah, so,
Just briefly, Your Honor, I mean, we agree that when Renzo Hernandez and Colonel Chatelain left the McDonald residence, the garage door was not damaged. It would happen after that fact.
That's not true, Your Honor, because
one at a time.
It happened after the fact. That's when McDonald called them and asked if they knew where a garage door repairman was, and they provided information to him. The garage door was not damaged when they visited. They were there for 10 to 15 minutes. After they left, that's when they received a phone call from Mr. McDonald asking for a repairman.
Whether a repairman was called for or not, it's our understanding that the door was damaged when they arrived, and that we can establish that. That's what I'm trying to develop in the testimony.
And I can take your profit too, but what is, you're saying that those military, I guess one or two guys showed up all the time?
Early that morning.
Judge, I know from the Colonel Chatelain's statement, as well as the gate codes, I believe they arrived, I believe it was 11:56, so just before noon. I'll double check, but it was shortly before noon when they arrived and stayed there for approximately 10 to 15 minutes.
And they're saying it wasn't like that?
The garage door was not damaged when they left.
11:56 a.m.?
They arrived in the neighborhood. They accessed the gate at 11:56. I may be a minute or two off, but approximately that time. They visited Mr. McDonald for approximately 10 to 15 minutes inside of his house. They then left. After they left, they received a call from Mr. McDonald asking for a garage door repairman because he had damaged the garage door.
And shortly after that, he took off to the gun neighbor?
Yes, he left in a different vehicle, the Jaguar, and it's a Naples.
And our understanding is that the door was damaged when they arrived. It was not damaged to that extent.
I got all these exhibits he offered, and even admitted, even Mr. McDonald says on the medical reports that he was in a hurry to get out. He reversed, knocked the garage door down. He was going to buy a gun because he was worried about his wife missing, and he wanted his own safety. So his own statements appear in the exhibits. That's enough for me.
We're not disputing that the door got damaged by Andre McDonald when he was coming out of his garage. We're just disputing that the door was not as damaged as it appears in the exhibits Your Honor has before it. That someone else observed door damage at an earlier time in the day, and that it wasn't that badly damaged. The implication we would maintain of that is that the damage that is being observed here, it was done later by someone else, which could include BCSO officers. And that, in fact, the timing as we have suggested, and when the note was observed and by who and who that was communicated to, are equally, if not more likely, of an explanation about how warrant number 2 comes into existence as the state's theory, which, as far as I can tell right now, is being propped up based on an unsworn report from Lorenzo that says that it's at 1:16, in contradiction of the sworn statement.
I'm sorry.
And in contradiction of the sworn statement of Frank Stubbs in his affidavit, and an inventory form from Sampson that says that the note was in his pockets. That's really, at the heart of it, the only thing the state has to contend that their theory of this should be taken over any other explanation. And frankly, that isn't sufficient.
And so you want to hear from Lugo for short, and who's the other one?
Lugo for sure, and then this is...
You said they're not long, right?
These are not long. And then Renzo Hernandez.
Renzo Hernandez.
And Your Honor, I think it may be a benefit to the record. I've just marked this State's Exhibit number 25. This is an email from Lieutenant Colonel Stephen Chatelain to OSI in terms of his statement, where the first of all, tender to defense.
I wouldn't have an objection, but under optional completeness, I would like for all of Chet Latt's emails to be admitted with this.
Well, just offer it if you want, the rules of evidence don't apply again. If you want to give me something, give me something.
Okay. And the statement offer states 25, and just for purposes of the record, after the narrative of their visit at the McDonald residence, Colonel Chetlet says, we left at approximately 12:40, and Major McDonald called at 12:54, saying he had damaged his garage door. Major Hernandez looked up a repair place for him. And I'll tender that to the court. And, Your Honor, you could also note from the exhibit that Chetlet does not say that he sees the Porsche during that time frame, further showing that the garage was intact at the time. At the time of their visit, I should say.
I'm sorry.
At the time of their visit.
All the more reason why we need to call Renzo Hernandez and Lugo.
So his statement here is saying that he couldn't see the Porsche, it was in the garage, where Andre told him, and so all he sees is the Jaguar that outside that he's later at the gun store with.
Yes, the Jaguar is where the vehicle he uses to go to the gun store. We're just stating that when Colonel Chetlet and Major Hernandez were there, they make note of seeing the Porsche outside. Then, of course, when they received that phone call after they had left, that Mr. McDonald has damaged the garage door. And of course, as the court saw from the photos, the damage to the garage door and the Porsche inside.
He damages the garage door, and then 20 minutes later is when they see he's saying he's got a call, the commander from the defendant, the door was damaged, 12:54. They looked up a place to Hernandez to repair it for him. 1:16. Officers are getting there, seeing it within like 30 minutes later, they're seeing it like that, or at least what pictures they have, what their testimonies to.
Correct, Your Honor.
So, what do you want them to say different?
I think that Renzo Hernandez is going to testify that he saw damage to the door. The fact that he called later and asked about a repairman is a different factor entirely. The idea that we didn't see the Porsche doesn't mean that the door is in perfect condition. Means the door isn't as damaged when it's observed then as it's observed later. I think that that's what we can develop through Renzo Hernandez. Now, and quickly, I think it'll be really simple. I'll ask, he's either going to confirm what I think, or he's going to tell me I'm wrong. It'll be a very simple examination. All I do, interestingly, want to point out that if either way, if we really want to think about this in a more global sense, knowing that Chetlet, his commanding officer, is later that very day down at BCSO assisting in the further prolonged detention of Mr. McDonald for mental health watch, that we can again consider this from an information acted upon and collective knowledge of law enforcement position. The idea that there should have been a community caretaking officer sent by command down to Solitude Cove that day makes even less sense, because someone within the greater collective group of officials that are investigating Andre McDonald and assisting in his detention, Chetlet, has been told explicitly that this is an accident that happened 10 minutes after he departed. If you want to read the email the way that they're suggesting. I do think that Renzo Hernandez is going to contradict that statement. But even if that's not the case, I think we need to consider that as well. This idea that, oh my God, this door's broken open, there must be a burglar inside, doesn't hold water, because everybody knew that that was not true. Either way, but it will be a very short day tomorrow, Your Honor, I assure you.
So both of them aren't available now?
We don't have either of them.
Okay.
We can be done before noon tomorrow. We can be done before 11 probably.
Any response on the from the state about the arrest not being legal at Naples?
And Your Honor, again, we say it was an emergency detention, but clearly he is in custody. The officers under there did not know if he had a weapon on him. It's clear he didn't have a weapon in his hand. That's obvious. But because of the situation, Sergeant Tobelman describes many people inside the store. people outside of the store. The situation could go sideways very, very quickly, and they needed to make a detention of Mr. McDonald based upon those purposes, as the court saw in that video. At that point, you have an individual who his wife was missing. They had found blood inside the house. They had found a burn area in the back. They had witnesses that know that he had had issues with his wife and that he had assaulted her in the past. Coupled with the fact that he's now damaged his house, trying to back up the vehicle, and now he's trying to get a gun. All these kind of lead towards the officer's thought, is this person a danger to himself or others? After the decision was made by the sheriff's office that Mr. McDonald did not meet the criteria of an emergency detention, prior to that, his lieutenant colonel, Mr. McDonald's immediate commander, Stephen Chatlet, had made a decision based upon all those, as the court, I believe, has seen in the medical records, his rationale for why he's doing the command-directed evaluation of Mr. McDonald. He informs him of such. The paperwork is in there. He is concerned as to it. So, again, no search is done of Mr. McDonald that covers a note, or uncovers a note, I should say. The note is discovered.
Even though it states that a legal arrest, you're still saying that the hospital or VAMC or whatnot got it later through a legal avenue?
Yes, through an inventory of his property, an independent decision made by Lieutenant Colonel Stephen Chatlet to do the command-directed evaluation.
We would respond to that in two ways. First, the illegal arrest flows directly into the detention. There's no break in custody. And without the arrest, we can't say one way or the other whether Chatlet, who had just met with him that morning and said that he was fine, had no concerns about his mental health, would have made the same directive that he did. Secondly, we would maintain that under the DOD information that's given for these CDE detentions, that he doesn't meet the criteria objectively. That Chatlet's contention that he should be detained was not in good faith. That it was based in part on the representations of law enforcement that he was trying to buy a gun, they were afraid he was going to kill himself. But in the medical records that are before Your Honor, there is evidence that would indicate that that was really kind of up in the air. On the one hand, sure, buying a gun after your wife goes missing, that's maybe a little odd. But on the other hand, who buys 4 boxes of ammunition when they plan on killing themselves? There is inconsistency within that. All the while within those records, Andre is saying, I feel fine. There's nothing wrong with me. I was buying a gun for protection because my wife went missing. I don't feel like I have a need for any psychiatric help. So, I mean, there's no criteria there, and that under that rubric, irrespective of that, finally, assuming everything else is denied on that under the Boxer law and HIPAA, there is a reasonable expectation of privacy in your medical file, which would require a warrant. But this information, which has been testified to, was placed in his medical file, was just handed over to law enforcement.
The list, they copied it in there and put it in there like the way you gave it to me.
I'm sorry, what, Your Honor?
The way you gave it to me, they copied it on both sides and put it in there.
That's my understanding, yes. Also, Your Honor, in Frank Stubbs' report, he indicates that he interfaced with OSI to get the suspect taken into their custody on a command mental health evaluation once we took him into custody and processed him for clothing and photographs. I was briefed by numerous investigators and deputies about details that they had learned regarding the suspect and the MP. Let's mark this.
What I'll do is, I'm not sure you're going anywhere with the Frank's issue tomorrow, but I'll hear those witnesses, and I always can change my mind. At the same time, the rest was pretty weak to me, but I could change my mind if something else argues tomorrow, but I'm going to, based on what I read or any case law, but that's where I'm leaning. It's not saying I'm going to change my mind based on, or won't change my mind based on any arguments you make tomorrow either way, but I'll let you do your witnesses tomorrow, and then you can make arguments on the suppression of every issue that y'all got.
Thank you, Judge. We just offer defense 40, which is what I just read into the record from Frank's.
I'm just reviewing, Judge, just one moment.
Let me ask you, just so I can know where you're going, as far as if I go that route and say the arrest is not legal, obviously that would throw out the note. I guess it's shopping list. With this, is there going to be something else the state's going to argue with taking that out with the medical records 19? Is there some kind of business record or custodian you're bringing, or is that something y'all are going to be trying to keep out or keep in, or is that legal issues on that?
Oh, Your Honor, we filed the medical records with the business records affidavit months ago. I don't remember the exact time, but certainly within the time frame in that regard. And we would intend on offering the medical records. I can understand the court has to redact certain aspects of it, and also the doctor's involvement with Mr. McDonald.
We would contend that any statements Andre McDonald makes, I mean, I don't think that they're actually unfavorable, but frankly, just on principle.
What does he say, that he's just buying a gun for safety and
his wife is missing and he feels fine? I mean, those kinds of things.
I didn't look at it all like you did it carefully, but there's no admissions in here of any,
I mean, there's some discussion, I think, that they've had a rocky relationship. There may be some things to that effect in there, but I don't think it's especially bad, and it may help us, but what I'm just saying is it's fruit of the poisonous tree. But for the unlawful arrest, none of this would have happened.
And, Your Honor, it's our contention, Colonel Chatlat's reason to do the command-directed evaluations. One, it's clearly within his authority. It's separate and apart from any decision made by the sheriff's office. And then
but that wouldn't even happen in the first place if he didn't get tackled and arrested, not arrested. It wouldn't have happened at all. I mean, the major commander didn't sound like he was going to be doing any of that until this happened. Right?
Well, and as defense has pointed out earlier in the day when he visited him, roughly around noontime, at that point he may not have had a reason. Post that time, he's now done damage to his garage door and then gone to try to buy a firearm. As Colonel Chatlat articulates that he's worried about Major McDonald trying to hurt himself or someone else. So, again, the records themselves would be offered, obviously done for medical purposes by the SAMC personnel.
We would call the court's attention back to Frank Stubbs' remarks in Defense 40, Defense 40 that I'm offering, where he's pretty unequivocal about it. The Chatlat was brought in because BCSO was asking him to make this CD. And how do we really get the salt out of the Ganges there? How do we really say how much of it is Chatlat's own independent judgment, even though he had prior judgment earlier that day that was fine, and how much of it is what BCSO is telling him after having tackled him to the ground and held him there for several hours, unable to make the detention.
And, Your Honor, in Defense 40, I mean, as throughout this entire case, it's just simply the Sheriff's Office communication with OSI, as they would do any time they have a service member either in custody or detained for any reason. So that clearly there are communications because they want to let them know.
But I mean, the detained, if I say it's illegal, I see what the defense is saying too. It's an illegal takedown, arrest, and everything. And then they're saying, oh, well, we better take him in. This sheriff's department over here said something's bad going on and arrested him or holding him. And maybe even from their side, let's go make sure our guy's okay. Let's take him over here. I don't know if that would have happened without the incident in Eagles. Then again, we don't know what he was going to do with the gun either. So, but I'll look at all these things and then we'll let your witnesses tomorrow. You can argue again. Okay.
Thank you, Judge. Is Defense 40 admitted?
Yes.
Yeah, we have no problem with it.
Would you mind?
Yeah.
You can get into the witness.
We'll start at 9:30, and I'll let you make your arguments again. I want to take another hour of arguments in each thing because I've already heard a lot of them already, but I can sum them up and make it easier. Okay. Thanks.
Absolutely, Judge.